The best part about stories, you remember them. They stay with you. And I want to tell you a bedtime story. Rest your tired bones.
Ryan Reynolds' failed television venture on Fubo, the maximum effort channel he launched several years ago, was abruptly canceled in 2025, shortly after the lawsuits began unfolding. One of the featured programs on that channel was Bedtime Stories with Ryan Reynolds, created and released in 2023 with a total of 10 episodes. The channel itself was not specifically designed for children, and at the time, it wasn't entirely clear whether the content of the series was truly meant for kids. Now, years later, Ryan has licensed those same 10 episodes to Nick Jr., where they will begin airing on March 2nd. The episodes are scheduled to run nightly for about 2 weeks until full first season is aired. Yes, he has signed a licensing deal with Nick Jr., and if you're wondering, Nick Jr. is a preschool-focused channel. We're talking about programming along the lines of Dora the Explorer and Blue's Clues. This isn't teen content. This is toddler content. The news broke yesterday via Deadline, announcing that the first season will air Monday through Friday, March 2nd to March 13th, at 9:30 p.m. on Nick Jr. in the series. Reynolds reads both classic and original bedtime stories as the tales come to life around him, creating what the release describes as a warm, playful, and imaginative wind-down experience for kids and parents to enjoy together. The show was created alongside George Dewey and originally aired on Fubo. Ryan has said he developed the concept because he struggles with anxiety and wanted to share the bedtime stories he reads to his own children. But when it originally aired, some viewers found it unsettling. His deep, dry delivery, the moody lighting, and the animated cheap sequences gave the show a tone that some described as odd rather than soothing. The humor, reminiscent of his Deadpool persona toned down for parenthood, didn't always feel traditionally child-friendly. So why would Nickelodeon pick this up? Well, Paramount owns Nickelodeon. And interestingly, Josh Greenstein is now at Paramount. It does appear Ryan may have a first-look deal there. What seems to be happening is that he's licensing reruns of a previously aired series that struggled on a channel that ultimately folded due to low ratings. Maximum Effort channel was canceled on Fubo reportedly because of weak performance. And while Nick Jr. does have consistent viewership, its late-night ratings are generally modest, often under 100,000 viewers per hour. This isn't Nick at Night. It's not adult programming. It's strictly children's content. So from 9 to 9:30 p.m., toddlers who can't sleep may now be tuning into Ryan Reynolds narrating bedtime stories. Financially, this likely isn't a massive payday. It's rerun licensing for pre-produced content. Essentially, it's a way to generate additional residual income from an already packaged project that didn't thrive in its original run. After the announcement circulated, including coverage from Entertainment Tonight, social media reactions appeared mixed and negative. Many commenters expressed disinterest, saying they prefer to read to their own children. Others questioned whether the tone of the show was a fit for preschool programming. Memes flooded comment sections, along with skepticism and sarcasm. The reaction suggests that while some remain supportive of Ryan's creative ventures, others are doubtful that this particular series aligns with Nick Jr.'s traditional preschool brand. Time will ultimately tell whether the rerun licensing move revitalizes the show's audience, or if it remains a short-lived programming experiment. If Bedtime Stories with Ryan Reynolds is really coming back, someone please confirm it's not the version where the hero manufactures drama, raises his voice for hours, and somehow walks away with someone else's project in the end. Classic storyline, right? That's the kind of sarcasm flooding comment sections right now. When the announcement dropped, the reaction online was intense. People weren't exactly celebrating. Many were asking, who thought this was a good idea? Others were practically begging Nickelodeon to read the room and check the comments before pushing this further. Interestingly, if you look at Nick Jr.'s own social pages, they haven't heavily promoted it. That might not be accidental. Nick Jr. is known primarily for brightly colored preschool cartoons, the comforting world of animated characters, gentle lessons, and soft storytelling. Adding a previously aired series led by a major Hollywood personality feels like an unusual fit for that brand identity. A lot of commenters openly said they would rather read to their own kids. Some even said they would prefer almost anyone else hosting bedtime programming. Whether exaggerated or not, the tone of the backlash suggests that this isn't being welcomed as a heartwarming addition, at least not by the loudest voices online. Now, to be fair, internet reactions can be amplified. Sometimes Reddit threads coordinate commentary waves, and social media doesn't always represent the broader audience. But even accounting for that, the visible engagement has skewed negative. There aren't many viral, this is adorable reactions circulating. Instead, there's skepticism, sarcasm, and a lot of side-eye. From a business perspective, though, the move itself makes sense. Licensing already produced content is one of the easiest ways to generate incremental revenue. The show was created in 2023, filmed, edited, and packaged. Those production costs are long absorbed. Selling it to Nick Jr. for a short 2-week nightly run is essentially found money. It doesn't require new filming, new marketing campaigns on his end, or additional development. It's a monetization play. And when you zoom out, monetization seems to be a consistent theme lately. Ryan Reynolds co-owns Wrexham AFC alongside Rob McElhenney, and what they have done with the club from a branding perspective has been remarkable. They bought a struggling Welsh football team and turned it into a global story. The documentary exposure, the Hollywood narrative, the community revival angle, it worked. The club climbed divisions, gained worldwide fans, and dramatically increased in valuation. But football, especially when you're chasing promotion, is expensive. Stadium redevelopment, player wages, transfer fees, infrastructure upgrades, those numbers escalate quickly. Reports surface about public grant funding being used towards stadium improvements, which triggered backlash from some local voices questioning why public funds were being allocated when celebrity ownership was involved. Whether fair or not, it created noise. Shortly after that period, minority stakes in the club were sold. Apollo Sports Capital acquired a minority share in a deal valuing the club at roughly $350 million, with funds earmarked for redevelopment projects, including improvements to the racecourse ground. Additional investment reportedly came from the Allen family in the United States, acquiring another percentage of ownership. This is unusual in sports ownership. Bringing in minority investors is common practice, especially when clubs are scaling rapidly. It spreads risk and injects liquidity. But it also signals that expansion costs are significant enough to require external capital. Some analysts speculate that the long-term play could be valuation growth followed by eventual majority exit. Build the story, elevate the brand, increase the worth, and then sell at peak momentum. That's a classic private equity-style growth strategy. Whether that's actually the plan here is unknown, but structurally, it wouldn't be surprising. At the same time, Reynolds' entertainment slate hasn't been packed with immediate theatrical blockbusters lately. One upcoming project is reportedly headed to Apple TV+, and there's chatter that was filmed years ago and sat unreleased for an extended period. Streaming deals can be lucrative, but they don't always generate the same public perception as billion-dollar box office headlines. And that perception matters. Ryan has long been associated with savvy business wins, aviation, gin, Mint Mobile, strategic marketing campaigns. He cultivated an image of being both creative and commercially sharp. That brand identity is powerful, but it also creates expectations. When smaller licensing moves or minority stake sales happen, observers interpret them through that lens of IT doesn't mean financial collapse. It doesn't mean crisis. But it does mean recalibration AS for the Nick Jr. deal. The financial upside is probably modest. It's rerun licensing, not a massive original production contract. The ratings expectations are relatively low compared to primetime network programming. If it performs decently, it quietly generates revenue. If it doesn't, it cycles out after 2 weeks. The louder story right now isn't the business mechanics. It's the cultural reaction. Some people simply don't feel the tone aligns with preschool programming. Others may just be fatigued by celebrity omnipresence. Public sentiment shifts quickly, and once audiences feel overexposed, they can turn skeptical. One comment that circulated referenced businessman Steve Sarowitz, who publicly questioned billionaire narratives surrounding Hollywood figures. That kind of statement can sting when brand identity is built partly on perceived financial dominance. Whether accurate or not, those remarks feed into broader discussions about valuation versus liquidity, ownership versus leverage, and media image versus balance sheet reality. Ultimately, none of this proves financial distress. But it does show a pattern of diversification, licensing, partial stake sales, and strategic partnerships, all signs of active capital management rather than passive wealth sitting untouched. The Nick Jr. experiment will either fade quietly or surprise people. But what's clear is this: the public conversation isn't about soothing bedtime storytelling. It's about optics, positioning, and whether the audience still buys the narrative. And right now, at least online, that narrative is being questioned more than applauded. One of the recurring talking points in this situation has been the word billionaire. Ryan has previously suggested that a billionaire is trying to destroy him and his wife. But critics have pointed out something simple. If he were truly operating with unlimited billionaire liquidity, would he need outside capital to fund ventures like Wrexham AFC? Would he need to license older content to networks like Nick Jr. for incremental revenue? That's where the skepticism begins. Several months ago, Someone claiming to have insight into financial dealings related to MELTDOWN, the ad tech company Ryan has been involved with, reached out and suggested that early in the dispute, Ryan may have believed that throwing $10 million at aggressive litigation would be enough to protect both his and Blake's reputations. The idea, allegedly, was that a strong legal offense could quickly suppress reputational damage and allow them to move forward. What may not have been anticipated, according to that account, was serious resistance, particularly from businessman Steve Sarowitz, who is known to have substantial financial resources. Litigation becomes a very different strategy when the opposing side is equally or more equipped to sustain a prolonged fight. And prolonged as Blake's legal representation reportedly includes major firms with billing rates estimated between $1,200 and $2,500 per hour. Wilkie Farr & Gallagher, another powerhouse firm, often commands similar rates. Add to that crisis PR management, including a former intelligence official assisting with strategic communications. When you combine multiple law firms, dozens of attorneys, consultants, filings, and over a year of active litigation, costs escalate quickly. While there is no official public accounting, some legal analysts have speculated that total expenditures could be approaching or exceeding $20 million. That's an extraordinary figure, especially if there is no decisive win to show for IT at the same time. Neither Ryan nor Blake has released major new theatrical projects during the height of this dispute. Revenue streams from film appearances appear limited during this period. Meanwhile, Reynolds has had to continue funding and investing in Wrexham Stadium improvements, player acquisitions, and infrastructure expansion, which, as discussed, required bringing in minority investors. Observers have also looked at his business ventures. Aviation Gin, once a strong brand success story, operates within a spirits market that has reportedly experienced a slowdown in growth. Mint Mobile, which Reynolds helped promote before its sale to T-Mobile, still relies heavily on brand perception and marketing personality. Any reputational turbulence can impact endorsement-driven businesses. And that's the key issue. His brand is his asset. Ryan's public image, witty, sharp, likable, commercially savvy, fuels the value of everything attached to his name. Many partnership agreements include morality or reputation clauses designed to protect brand equity. If public perception shifts significantly, that can have downstream business implications. What's also interesting is the procedural shift in the lawsuit itself. For months, there was aggressive motion practice, sanctions motions, anti-SLAPP filings, attorney fee disputes, evidentiary challenges, and attempts to disqualify opposing counsel. The docket was active, almost relentless, but after key evidence was unsealed and certain hearings occurred, filings reportedly slowed. Silence in litigation can mean many things. Sometimes it's strategic patience while awaiting a judge's ruling. Sometimes it signals reassessment. Judges often frown upon excessive or duplicated motion practice, and there may come a point where both sides recognize diminishing returns on procedural skirmishes. If significant portions of the case were dismissed or narrowed, the long-term consequences would become the next focal point. Would there be countersuits? Fee shifting? The bigger issue is sustainability. Litigation at this scale is not just emotionally draining, it's financially draining. Even extremely wealthy individuals can feel pressure when legal bills run into 8 figures with no guaranteed outcome. Courtroom battles of this magnitude are rarely quick. They stretch across months, sometimes years, consuming capital, time, and strategic focus. And unlike a business investment, there is no predictable return. It's capital deployed defensively, not productively. There's also the broader strategic risk. If a court were ever to characterize aspect of the case as weak, excessive, or unsupported, that narrative could linger publicly long after the legal matter ends. Court rulings don't just settle disputes. They shape perception. Headlines crystallize around judicial language. A single line in an order can echo for years in media coverage, analyst commentary, and for now. What's visible is a combination of high legal spending, monetization of older projects, partial stake sales in major ventures, and quieter entertainment output. That doesn't automatically signal collapse, but it does suggest active financial maneuvering. Whether that's prudent strategy or reactive scrambling depends entirely on how the legal battle ultimately resolves. And until that ruling comes down, speculation will continue about liquidity, about leverage, and about how much reputational capital is left to spend. When public figures build careers around personal branding, the value of that brand becomes intertwined with every venture attached to their name. In Ryan Reynolds' case, his entrepreneurial image, from Aviation Gin to Mint Mobile to ownership of Wrexham AFC, has been central to his market identity. He isn't just an actor, he's positioned as a savvy dealmaker. That persona enhances valuations, drives partnerships, and attracts investors. But reputational volatility introduces uncertainty. Investors don't just look at revenue, they look at stability. They look at distraction risk. They look at whether leadership is focused on growth or consumed by litigation. Even if the underlying businesses remain sound, perception alone can affect deal terms, valuation multiples, and appetite for expansion. Litigation also shifts opportunity cost. Time spent coordinating with legal teams is time not spent on creative development or strategic planning. Media cycles that would normally highlight film releases or business milestones instead center on court filings. For a personality-driven brand, that shift in narrative matters. There's another element here: endurance. Legal disputes often become battles of stamina. The assumption that one side will eventually fold under financial or reputational pressure is common. But when both sides possess significant resources, including individuals like Steve Sarowitz, that calculation becomes more complicated. Deep-pocketed adversaries change the math. What might have been a short tactical strike can evolve into prolonged trench warfare, and prolonged warfare is expensive. Beyond hourly billing rates for elite firms, there are experts, consultants, document production costs, forensic analysts, deposition transcripts, travel, and crisis communications. High-profile litigation requires coordination across legal, PR, and business teams. It becomes an ecosystem of expenditure. At the same time, entertainment income is cyclical. Actors typically rely on staggered project pipelines. Filming one year, releasing the next, marketing thereafter. A slowdown in visible releases doesn't necessarily mean inactivity, but it can create gaps in cash flow timing. If projects are delayed, shelved, or redirected to streaming platforms, revenue structures shift. Back-end participation tied to box office performance may be replaced by fixed streaming deals. That alters long-term upside potential. Meanwhile, in sports ownership, advancement up league tiers dramatically increases operational costs. Player wages escalate. Infrastructure demands grow. Marketing scales. While Wrexham's rise has been compelling narrative success, sustaining that trajectory requires continued capital injection. Bringing in minority investor spreads risk, but also dilutes ownership. It's a balancing act between control and solvency. Then there's a psychology of escalation. Once substantial sums have already been invested in litigation, it becomes harder to step back. The sunk cost effect can push parties to continue fighting because so much has already been spent. But rational strategy sometimes requires reassessment, weighing further expense against likely outcome. Silence on the docket, if it continues, could signal that reassessment, or it could simply mean procedural waiting. Courts move at their own pace. Judges deliberate carefully, especially in complex civil matters. A single ruling can narrow claims, dismiss portions, or allow discovery to proceed further. Each possibility carries financial implications that, if significant claims survive, costs continue climbing. If claims are dismissed, appeals could follow. Either scenario prolongs uncertainty. Uncertainty is rarely kind to markets or partnerships. Brands prefer clarity. Agencies prefer predictability. Studios prefer low-risk collaborators. While Hollywood is no stranger to controversy, ongoing litigation with high financial stakes is a different category than fleeting tabloid drama. There's also the human dimension. Even for affluent individuals, watching millions of dollars flow into legal fees can create internal pressure. Financial advisors begin modeling downside scenarios. Business managers project cash needs. Portfolio diversification strategies may shift to preserve liquidity. None of this confirms distress. Wealth at that level often includes diversified assets, equity stakes, and long-term holdings that aren't immediately visible. Net worth is not the same as liquid cash. Billionaire status, especially when tied to equity valuations, can fluctuate dramatically based on market conditions. But the central question remains sustainability. How long can this continue without materially affecting broader ventures? If the legal battle ends decisively in their favor, much of the speculation could dissipate. Victory reframes expenditure as defense well spent. If the outcome is mixed or unfavorable, reputational narratives may harden. And if it drags on indefinitely, fatigue alone can alter public perception. Ultimately, this is less about a single licensing deal or minority stake sale. It's about trajectory. Are these moves components of a calculated diversification strategy, or are they incremental responses to mounting pressure? From the outside, observers can only analyze patterns. High legal burn rates, monetizing back catalog content, strategic equity sales, reduced public appearances, a temporary cooling of creative output. Each piece alone is explainable, Together, they form a narrative of active capital management during turbulence, and until the court issues its ruling, that turbulence remains unresolved. Speculation will continue about liquidity, about leverage, about brand equity, and about how much reputational capital remains in reserve. Because in the end, for a personality-driven empire, reputation isn't just symbolic, it's collateral.
Through that documentary series, I met a young woman named Claire Wineland who had cystic fibrosis. Claire became like a little sister to me. And one day after we were filming, I had asked her just casually, have you ever dated? Like, give me the inside scoop. Like, what's it like in a hospital? Have you ever like dated anybody with CF? And she was like, no. And then she told me that two people with CF can't get closer than 6 feet, or they could really hurt each other. And instantly I said, that's a movie.
Stephanie Jones and Blake Lively appear to have been aggressively filing or encouraging multiple legal actions aimed at overwhelming Justin Baldoni's legal team. The strategy, at least from one perspective, seems designed to shift attention away from weaknesses in their own claims. By stacking lawsuits and bringing in additional parties against Brian Friedman and Melissa, the narrative attempts to reinforce the idea of a coordinated smear campaign. The argument seems to be that if enough individuals come forward, it validates the broader accusation. Even if the underlying foundations didn't point one such case surfaced in 2025, when the surviving spouse of a former client represented by Brian Friedman filed suit against him. That former client had previously sued Justin Baldoni over alleged copyright infringement. The new complaint accused Friedman of privacy violations, defamation against Travis Flores, breach of fiduciary duty, and legal malpractice. However, significant legal hurdles immediately stood out. First, the statute of limitations had already expired. Additionally, under long-standing legal principles, defamation claims do not survive the death of the person allegedly defamed. Once an individual has passed away, reputational harm is no longer legally actionable in most jurisdictions. As unfortunate as that reality may be, courts consistently uphold it. The timing of the lawsuit also raised eyebrows. The former client had tragically died from cystic fibrosis, and the sudden filing by the spouse in 2025 seemed unusual. Observers recalled prior text exchanges referencing complaints from individuals who had worked with Baldoni, along with broader discussions about past disputes tied to his productions. That context made the emergence of this lawsuit appear less coincidental to some. When Friedman formally responded, he did so with documentation. He attached the prior settlement agreement from the earlier copyright litigation and provided evidence demonstrating limited direct interaction with Baldoni. Most communications, according to record, were conducted through corporate entities involved in production, including CBS, Lionsgate, and Wayfarer Studios. The defense further showed that approximately 1,500 pages of materials had been exchanged, and those documents allegedly demonstrated that the screenplays were materially different and independently developed. In January, Friedman filed an anti-SLAPP motion in California, seeking to strike the complaint. He argued that several claims were time-barred, others arose from protected speech connected to judicial proceedings, and some implicated matters of public interest. He emphasized that defamation and privacy claims cannot be asserted on behalf of a deceased person, and that litigation privilege shields statements made in the course of legal disputes. Regarding malpractice and fiduciary duty allegations, Friedman contended that he never simultaneously represented Flores and Baldoni in the same matter. Any later representation of Baldoni was unrelated and not substantially connected to the earlier case. He also denied disclosing any confidential or privileged information. In his declaration, Friedman stated that after the original copyright case was filed, opposing counsel provided detailed explanations asserting no access to Flores' script and confirming independent creation. On October 18, 2021, he received a comprehensive letter from counsel representing CBS Films, Lionsgate Entertainment, Wayfarer Entertainment, and Justin Baldoni. That correspondence outlined their position regarding lack of access and creative independence, which ultimately factored into resolution of the dispute. The correspondence also went into extensive detail about the development of 5 Feet Apart, outlining the creative timeline and the origins of the project. It further referenced Mr. Baldoni's philanthropic initiatives. A complete and accurate copy of that letter was attached as an exhibit. After receiving it during the Flores litigation, the defendants supplemented their position by producing documentation supporting their independent creation and lack of access defenses. Ambry Genetics Corporation, in particular, generated nearly 1,500 documents. None of those materials suggested that Ambry had ever transmitted Mr. Flores' screenplay to any outside party, including Mr. Baldoni. Those records had not been accessible to Mr. Flores or his counsel prior to filing the complaint. Following several agreed extensions to allow review of the newly produced materials, Ambry ultimately moved to dismiss on the grounds that the complaint failed to state a viable claim on March 9th. The parties resolved the Flores matter through a non-confidential settlement agreement that concluded all pending claims. A copy of that agreement was included with the declaration. Friedman stated that he did not meet Mr. Baldoni until late December 2024, more than 2 years after the prior case had ended. Shortly thereafter, Baldoni retained him in connection with litigation involving Blake Lively and others. According to Friedman, the Flores dispute and the Lively-Baldoni litigation are entirely unrelated in subject matter and legal theory, i.e. in January 2025. Media outlets covering the newer litigation sought comment regarding the fact that Friedman had once represented Flores in a separate 2021 copyright case against Baldoni. His response did not reference Flores by name and did not rely on any confidential communications. Instead, it summarized publicly available aspects of the prior settlement and information obtained from opposing parties during that earlier case. He also referenced Baldoni's charitable involvement, including Wayfarer Entertainment's philanthropic foundation, attaching the statement as an exhibit. Friedman further stated that on January 30th, he was informed that Mr. Clement, identified as Flores' surviving spouse and estate administrator, requested a copy of the legal file from prior litigation. In response, his office provided a thumb drive containing approximately 635 megabytes of material, including pleadings, discovery, correspondence, billing records, agreements, and electronic communications. Receipt was acknowledged on February 14, 2025. Of the 236 emails included, 175 consisted of communications with opposing counsel. Friedman emphasized that neither he nor his firm ever represented Flores and Baldoni simultaneously. The allegedly defamatory statement at issue simply reflected Friedman's conclusion that the defendants in the earlier case bore no liability, and that the matter closed without any admission of wrongdoing by Baldoni, Wayfarer, or the other defendants. He characterized them as honorable and ethical based on the outcome. He did not comment on Flores' character, reputation, or personal traits, nor did he reference his name in the media response. The CBS letter cited in the record, issued by outside counsel, explained that an internal investigation found no evidence of copying. The film, it stated, was inspired by Claire Wineland, a cystic fibrosis patient featured in Wayfarer's web series My Last Days. According to the letter, neither Baldoni nor the screenwriters were aware of Flores' screenplay, much less had access to it. Allegations that access occurred to an individual named Caleb Remington were addressed with documentary proof showing Baldoni and Remington did not meet until after the first draft, which already contained the core elements identified as allegedly similar, had been completed. The documentation, counsel asserted, conclusively demonstrated independent development. Moreover, a comparison of the works revealed no legally cognizable substantial similarity. Any overlapping elements derived from general themes common to stories about teenagers confronting serious illness, cystic fibrosis in the film, and various life-threatening conditions in the screenplay, along with standard narrative tropes that naturally arise from that subject matter. The letter goes on to explain that the alleged similarities stem from subject matter that is not legally protectable, namely, general themes involving cystic fibrosis, terminal illness, and teenage romance. These are broad concepts that naturally arise when telling stories about young people facing life-threatening conditions. Copyright law does not protect ideas, genres, or common tropes, only specific expression. The correspondence then provides detailed background on Claire Wineland. Claire tragically passed away in 2018 following complications from a double lung transplant, including a stroke. Years earlier, Baldoni became aware of her while working on his documentary-style web series, My Last Days. He initially discovered her through her involvement with an educational initiative focused on terminal illness awareness, often referred to as a Clarity Project. Claire had created deeply personal video content about living with cystic fibrosis, documenting her hospital stays, treatments, fears, and hopes. Baldoni publicly amplified one of her videos, describing her as profoundly inspiring. That interaction led to a personal meeting, and she was later featured in an episode of My Last Days. The letter describes Claire as extraordinarily charismatic, vibrant, and authentic. Much like the character Stella in 5 Feet Apart, Claire built a significant social media following by openly chronicling her medical journey. Many of her videos reached millions of viewers, resonating with young audiences navigating illness and adversity. After developing a friendship with Claire, Baldoni conceived the idea for a feature film centered on the emotional and psychological experiences of a teenage cystic fibrosis patient. The concept focused on the tension between wanting to live fully, embracing love, youth, and connection, while confronting a disease that imposes strict physical limitations and life-threatening risks. In April 2016, after spending time with Claire, Baldoni pitched the concept to CBS. By August 2016, he was formally engaged to develop and direct the project. Two writers, Mickey Daughtry and Tobias Iacones, were brought on to draft the screenplay. In January 2017, Claire herself was retained as consultant, further grounding the film in authentic lived experience. Her influence was not superficial. It shaped tone, characterization, and emotional truth. The timeline becomes critical. By March 22, 2017, the first full draft of the screenplay had been completed. The letter emphasizes that virtually every element later alleged to be similar to Flores' screenplay was already present in that March draft. The story centered on Stella and Will, two 17-year-old cystic fibrosis patients navigating a fragile romance constrained by medical rules requiring physical distance. Stella's best friend, Poe, was also present in this early draft. Additionally, Stella's backstory, including the death of her sister Abby and her resulting survivor's guilt, was firmly embedded in the narrative. Abby's memory was symbolized through personal keepsakes like artwork and a childhood stuffed panda, adding emotional depth and continuity throughout the script. The claim that Baldoni obtained Flores' screenplay through Caleb Remington is addressed directly. The letter asserts this allegation is not merely inaccurate, but chronologically impossible. Baldoni did not meet Remington until late April 2017, after the March draft had already been completed containing the allegedly similar components. Supporting documentation, including email correspondence, was attached to establish the timing of that introduction. The comparison between the two works further undermines the infringement claim. Flores' screenplay centers on a teenage boy attending a camp for sick adolescents. The setting is a sleepaway camp environment filled with multiple characters, romantic entanglements, parties, social drama, and ensemble-style storytelling. It reportedly includes themes of teenage experimentation, substance use, and overlapping love triangles in contrast. 5 Feet Apart unfolds almost entirely within a hospital setting. Its tone is intimate, restrained, and emotionally focused. The narrative revolves around two medically vulnerable patients forced to maintain physical distance to avoid cross-infection, a restriction that becomes the central dramatic engine of the story. The romance is quiet and deeply personal, shaped by the tension of proximity without touch. The hospital setting reinforces isolation and seriousness rather than camp-style exuberance. Where Flores' work portrays broader social hijinks, group dynamics, and youthful rebellion, the film maintains a contained, medically driven narrative exploring mortality, discipline, and emotional resilience. The male versus female protagonist distinction, differing structural frameworks, tonal divergence, and distinct character arcs further highlight the absence of substantial similarity. The letter concludes that when evaluated holistically, considering plot, pacing, character development, setting, tone, and sequence of events, the works are fundamentally different. Any overlap arises from common elements inherent to stories about teenagers living with cystic fibrosis. Courts have consistently held that such generalized similarities do not constitute infringement. Taken together, the documentation, development timeline, draft history, consultant involvement, and independent creation evidence strongly support the position that the film was conceived and written without access to Flores' screenplay. The letter characterizes the claim as speculative and unsupported by the record, ultimately asserting that Flores did not possess a viable copyright infringement claim under established legal standards. The letter ultimately concludes that Mr. Flores lacked a coherent factual or legal theory to support the allegation that a screenplay had been accessed prior to creation of the film. It states plainly that there was no non-frivolous basis to claim substantial similarity under copyright law. In other words, even if one assumes good faith at the outset, the evidentiary record simply did not support the elements required to move forward. Importantly, the correspondence also highlights something that significantly undercuts the later claims. Prior to filing suit, Mr. Flores himself had not taken position that the film infringes rights. To the contrary, he publicly supported the film's release. He attended a premiere event, posted favorable comments about the project on social media, and made media appearances praising it. That conduct is difficult to reconcile with the assertion that he believed his intellectual property had been wrongfully appropriated. Over the years following the film's release, Flores reportedly maintained cordial and positive communication with Baldoni. The two exchanged text messages and remain on friendly terms. Baldoni assisted Flores in fundraising efforts related to his medical needs. Flores was also featured on My Last Days, further underscoring that the relationship was collaborative rather than adversarial. When Flores experienced personal struggles, Baldoni offered support as a friend. The The letter suggests that whatever motivated the later legal action, the objective record does not support claim of unauthorized copying. The screenplays differ substantially in structure, tone, setting, and character development. The documentary evidence, including email chains and draft timelines, demonstrates that Baldoni did not even meet Caleb Remington until April 2017, after the first draft of the film had already incorporated the allegedly similar elements. That chronology is critical because copyright infringement requires proof of access combined with substantial similarity. Without access, the claim collapses. Additionally, the settlement agreement resolving the earlier lawsuit was non-confidential. There was no non-disclosure obligation preventing the parties from referencing its general terms. The agreement expressly included mutual releases and hold harmless provisions. Each side waived future claims arising from the dispute. The document clearly states that there was no admission of liability by any party, and that nothing in the agreement should be construed as a concession of wrongdoing. It was a voluntary resolution entered into without coercion. That context matters when evaluating later statements made to the press. When asked about the prior case, Brian Friedman's comments summarized the publicly known outcome. The matter concluded without liability for Baldoni, Wayfarer, or the other defendants. He described his professional impression that they had acted ethically based on what he learned during the litigation. Notably, he did not disparage Flores personally, did not question his character, and did not reference private communications. The statement was narrowly tailored to the case's resolution. The timeline of media inquiries adds another layer. On January 22, 2025, a reporter from the Daily Mail reached out seeking comment regarding coverage of the earlier copyright lawsuit. The inquiry referenced the fact that Baldoni's attorney had previously represented Flores in a separate matter. The next day, follow-up emails were sent requesting additional details. Responses were exchanged among legal counsel, and a statement from Friedman was provided. Significantly, some recipients were copied while others were not, reflecting routine media coordination rather than anything unusual. Then, on January 30th, the surviving spouse of Mr. Flores reportedly requested a complete copy of the prior legal file. That sequence has prompted speculation among observers about whether outside parties may have encouraged a renewed legal action. While such theories remain speculative, the proximity of dates inevitably raises questions about timing and influence. It is important, however, to separate speculation from fact. The factual record presented in the response focuses on documentation, draft dates, email metadata, settlement language, and production records. These materials collectively support the independent creation defense. In copyright cases, courts analyze not only whether two works share superficial similarities, but whether protected expression, specific dialogue, plot structure, character arcs, and unique creative choices has been copied. Here, the comparison shows different narrative frameworks. Flores' screenplay centers on a camp setting populated by multiple teenage characters navigating friendships, romantic entanglements, and coming-of-age experiences in a group environment. It reportedly includes ensemble storytelling, party scenes, and broader social dynamics. In contrast, 5 Feet Apart is tightly focused on two protagonists confined to a hospital environment. The emotional core of the film revolves around medical restrictions preventing physical closeness. The central dramatic device, the mandated 6-foot distance reduced to 5 feet, drives the narrative tension. The mood is intimate, serious, and contemplative rather than socially expansive. Courts often emphasize that genre conventions cannot form the basis of infringement claims. Stories about teenagers with cystic fibrosis will inevitably share certain baseline elements: hospital scenes, medical terminology, references to treatment protocols, and emotional vulnerability. Those are scenes off air, stock elements that flow naturally from the subject matter. They are not protectable. The settlement agreement further weakens the suggestion of wrongdoing. Because both parties explicitly denied liability and agreed to release claims, the existence of the settlement does not imply fault. Settlements are frequently strategic decisions made to avoid prolonged litigation costs, regardless of the merits. The agreement's language clearly reflects that neither side conceded infringement. As for the renewed lawsuit filed by the surviving spouse, the legal challenges are substantial. Statutes of limitation, privilege doctrines, and the inability to pursue defamation claims on behalf of a deceased individual present formidable barriers. Moreover, anti-SLAPP protections in California provide defendants with procedural mechanisms to dismiss claims targeting protected speech connected to judicial proceedings or matters of public interest. If the matter proceeds to a hearing on the motion to dismiss, the court will likely focus on whether the complaint plausibly alleges access and substantial similarity. Based on the documentary timeline already submitted, those elements appear difficult to establish. Beyond the legal technicalities, there is a reputational dimension. Repeated filings that do not withstand scrutiny can create the appearance of overreach. In high-profile disputes, litigation strategy sometimes intersects with public relations strategy. However, courts evaluate evidence, not narratives. If filings lack factual support, judges tend to dispose of them swiftly. None of this diminishes the tragedy of Flores's passing or the emotional toll on his surviving spouse. Losing a loved one, especially after prolonged illness, creates vulnerability. It is entirely possible for grief and complex emotions to intersect with legal advice in ways that are not fully considered at the outset. That reality calls for compassion, not ridicule, at the same time. The documentary record described in the response appears comprehensive. It includes production drafts, data communications, third-party document productions, and a clear settlement framework. When viewed collectively, those materials support the conclusion that the film was independently developed and that no protected expression was copied. Ultimately, if the court reviews the evidence and grants dismissal, it will likely be because the legal standards for infringement simply are not met. Copyright law requires more than thematic overlap or shared medical context. It demands proof of actual copying a protected expression. From a broader perspective, the situation illustrates how complex creative disputes can become when intertwined with later, unrelated litigation. Past representation, settlement language, and media commentary can be reframed in ways that suggest impropriety, even when documentation says otherwise. Whether the renewed claims survive judicial scrutiny remains to be seen. But based on the materials outlined in the response, the factual timeline, draft history, and legal principles strongly support the independent creation defense. If anything, the detailed record may ultimately reinforce the conclusion that the two works share only generalized themes inherent to stories about young people facing serious illness, nothing more.
What we've seen from Blake Lively is her showing, who she really is. And the truth is, that there's a famous quote that says, when people show you who they are, believe them.
If you've been following the drama surrounding Blake Lively versus the rest of the world, things are about to get even more intense. On March 27th, the first pretrial filings are officially due in court. This came from a joint motion agreed by the judge, granting an extension for the Wayfair parties, and Lively to submit all of their pretrial motions. These motions include critical items like motions in limine, jury instructions, and responses to exclusions of expert reports. But there's an even juicier layer to this story. While everyone has been focused on summary judgment filings, one question has largely gone unasked. If this case actually proceeds to trial, what happens to the evidence obtained via the Vans in Law lawsuit? Imagine it as a high-stakes game of legal chess, all moves hidden from public view. This evidence existed long before whispers of Blake Lively suing Justin Baldoni reached the media that a company quietly filed a lawsuit in the court system. Secretive, discreet, almost invisible. The company is owned by Ryan Reynolds, Blake's husband. It's a John Doe-style lawsuit, wrapped in mystery. What's its true purpose? Is it a random procedural filing, or the opening move in a larger, more calculated battle? This is where the entire story begins. The lawsuit was filed without naming any specific defendants, targeting various individuals for alleged breaches of contract and reputational smears. The employees' reference were tied to Reynolds' parties, but the real goal was far more strategic: gaining subpoena power. This allowed Lively's team to access files of Justin Baldoni's former publicist, Jenel, potentially unearthing damaging information. On the surface, it appeared disconnected from the main case, but behind the scenes, it was part of a carefully calculated strategy. When the Vans and lawsuit surfaced in April 2025, it immediately raised red flags. It seemed like a shell company designed to launder evidence, taking documents from Stephanie Jones under legal veil, all while bypassing notice to key parties. Justin Baldoni, Jen Abel, and their teams were blindsided. When asked about this, Brian Friedman described it as a blatant abuse of process, so severe that he promised to pursue all available legal remedies. What's more, there appears to be no direct communication between Stephanie Jones and Vans regarding why her company or specific device was subpoenaed. No phone calls, emails, or documented discussions exist. It all seems covert, underhanded, and manipulative. The evidence obtained through this maneuver is now central to the case. It is also vulnerable in every civil trial. Both parties have the ability to challenge evidence before it reaches a jury. This is done through a motion in limine, a legal tool designed to preemptively block or limit evidence. For the Wayfair parties, this motion will likely target the materials derived from the clandestine Vans and lawsuit, which could potentially exclude the most explosive evidence from trial entirely What exactly is a motion in limine? Essentially, it's a preemptive strike. Rather than objecting in real time when a witness is about to speak or a document is about to be presented, attorneys can ask the judge to rule ahead of trial. This lets the court set the rules of the battlefield before the first word is spoken in front of the jury. Attorneys submit detailed arguments, sometimes supported by expert testimony or technical reports, to explain why certain texts, emails, or documents should be excluded. Common reasons include improper acquisition, undue prejudice, or potential to confuse the jury. The judge considers these arguments carefully, weighing relevance, admissibility, and potential harm. Is the evidence relevant? Does it unfairly prejudice the jury? Was it obtained in violation of anyone's rights? A motion in limine doesn't just block evidence. It shapes the narrative the jury will see. It's a legal kill switch, potentially removing entire categories of information from consideration. Sometimes, judges may grant it fully, excluding evidence entirely. Other times, they may allow partial inclusion, redact names or details, or set strict usage limitations. In some cases, the judge might hold a motion under advisement until the evidence is offered during trial. Rarely, the court may prohibit discussion of certain topics entirely, warning that violations could result in mistrial or sanctions, i.e. in this case. The motion in limine represents a critical battleground for the most sensitive and controversial evidence. It's where attorneys fight to define what the jury can see, and where judges exercise control over the story that ultimately unfolds in court. Why does this matter so much? Consider the jury, 12 ordinary individuals presented with sensational texts or scandalous emails. Even if the judge instructs them to disregard it, the human mind doesn't forget easily. A motion in limine is the only preemptive safeguard, giving the judge authority to keep evidence from contaminating jurors' impressions before trial begins. Lawyers understand the stakes. They spend hours, sometimes days, scrutinizing every document, every line of communication, and every piece of potential evidence. They anticipate objections, plan arguments, and prepare for counter-strategies, all in an effort to control what the jury will ultimately hear, in sum. The pre-trial phase in Blake Lively's legal saga is far from ordinary. Every motion, every filing, and every strategy plays a role in shaping the courtroom narrative. From clandestine subpoenas to preemptive legal strikes, the chessboard is set, and the outcome may hinge on which side can best control the evidence before it ever reaches a jury. When it comes to pretrial motions in Blake Lively's ongoing legal battles, the stakes could not be higher. Attorneys on both sides know that once the bell rings in a courtroom, evidence can't simply be unseen or undone. That responsibility falls squarely on the judge, whose role is to balance multiple factors, ensuring a fair trial, allowing the jury to see the truth, and preventing any evidence from unfairly tipping the scales. The judge often conducts numerous hearings behind closed doors, interrogating attorneys, testing the evidence, and evaluating the circumstances surrounding its collection. In the end, the court ensures that the story presented in the courtroom is both fair and legally sound, not merely sensational or headline dash-grabbing. I end cases like Blake Lively versus Justin Baldoni, where the reputation, careers, and public perception of multiple high-profile individuals are on the line. These decisions are critical. They shape not only the verdict, but also how the events will be remembered by the public. So, what legal arguments might be used to exclude evidence from trial? The central issue often comes down to tainted evidence, sometimes referred to as fruit of the poisonous tree. While this concept is traditionally applied in criminal law, it's also highly relevant in civil litigation when evidence is improperly obtained. Even if Blake Lively's legal team currently holds certain text messages or documents obtained through official court-supervised discovery, that doesn't erase the questionable origins of the evidence. Allegations suggest that Stephanie Jones improperly accessed the phone and private communications of Jen Abel, extracting iCloud data, text messages, and emails without her knowledge or consent. Once those materials were removed from the device and handled outside judicial supervision, the integrity of the evidence became compromised. Questions immediately arise. Was anything deleted, altered, or selectively copied? Who decided what to preserve or discard? This is where the chain of custody becomes essential. In any court proceeding, establishing an unbroken, well-documented chain of custody is fundamental to demonstrating that evidence is authentic and reliable. If evidence has been handled by unsupervised parties or in a potentially hostile environment, its credibility can be challenged. For the Baldoni legal team, this is a powerful point. They can argue that the very first time the messages or documents were copied, the process was already compromised. From a technical standpoint, this uncertainty undermines every copy, screenshot, or printed document that follows, no matter how carefully handled later under court supervision. The central legal question becomes, how can a court be confident that these messages are the originals? How can anyone verify what's missing, deleted, or altered? These questions strike at the heart of fairness in the trial. The fruit of the poisonous tree doctrine essentially holds that if the root of the evidence is tainted, everything derived from it is tainted as well. The ramifications are enormous. It could render critical evidence inadmissible, potentially altering the course of the trial. Judges in these cases must make nuanced and challenging decisions. They can completely exclude evidence if the chain of custody is irreparably broken or if the risk of manipulation is high. Alternatively, a judge may allow the evidence but issue a cautionary instruction to the jury, signaling that its authenticity may be in doubt and that they should evaluate it skeptically. Both approaches carry major implications. Excluding evidence could strip a party of crucial support for their claims, while allowing questionable materials could unfairly prejudice the jury's perception that a further complication arises if the court determines that the evidence was obtained through a sham lawsuit or a deliberately deceptive process. In such cases, this isn't just a technical violation of procedural rules. It constitutes procedural fraud, which is considered a serious breach of the duty lawyers owe to the court. Procedural fraud can result in sanctions against attorneys, exclusion of evidence, or even referral for further legal investigation. Ultimately, the issue comes down to trust. If the court cannot trust the evidence, the jury cannot rely on it, and the entire case risks unraveling. Adding another layer of complexity, questions surround Ryan Reynolds' involvement. Allegedly, his company facilitated the transfer of materials obtained from Stephanie Jones via the Vanzen lawsuit to Blake Lively for use in her ongoing case. If true, this raises serious concerns about whether evidence was moved or handled without proper judicial oversight, further undermining its legitimacy. The way the evidence was collected, transferred, and introduced could directly influence the outcome, potentially invalidating large portions of Lively's filings. Why does all of this matter so profoundly? The issue goes beyond isolated snippets of text or selective emails. Many news outlets, including the New York Times, publish fragments of communications, often out of context. These were sensationalized snippets curated for maximum impact, giving the impression of clandestine wrongdoing while concealing the broader context. If the full trove of communications were reviewed, the story could look very different. What seemed incriminating might instead reflect ordinary miscommunications, misunderstandings, or routine professional exchanges. Attorneys for Baldoni can invoke Rule 106, the rule of completeness. This rule allows them to demand that any snippet presented to the jury be accompanied by the full conversation or context. If Blake's team tries to show a single heated message or email, the defense can require that the jury see the lead-up, aftermath, and full dialogue, preventing cherry-picking or selective framing. Cross-examination becomes more meaningful with the complete record. They can demonstrate that the isolated snippet does not tell the full story, showing apologies, clarifications, or mitigating context that dramatically alters interpretation. Moreover, motions in limine provide a preemptive legal mechanism to shape the evidence presented at trial. These motions allow the judge to set boundaries before the jury ever sees a single document or hears a single testimony. Arguments can include claims that certain materials were obtained improperly, are overly prejudicial, or could mislead jurors. Judges can fully exclude, partially redact, or impose limits on the use of evidence, creating a structured and fair framework for the trial in high-profile cases like this. The courtroom is as much about strategy as law. Every filing, every motion, every objection is carefully calculated. Pre-trial motions, the handling of evidence, and the interpretation of technical rules all influence not only the final judgment, but also how the public perceives the parties involved. In the Lively versus Baldoni case, attorneys on both sides are navigating a complex web of legal and ethical challenges, from procedural issues to preservation of digital evidence, all while managing intense public scrutiny, in short. The upcoming pretrial motions and motions in limine are critical. They can determine which evidence survives, how presented, and ultimately, how the jury interprets the case. The court's decisions on these issues may define the entire narrative of the trial, from the admissibility of text messages to the integrity of critical digital files. For Blake Lively, Stephanie Jones, Ryan Reynolds, and all parties involved, these motions are not just technicalities. They're the battleground where the fate of the case will be forged. When it comes to Blake Lively's ongoing legal battles, the stakes couldn't be higher. The upcoming pretrial motions, particularly what is known as a motion in limine, often referred to informally as a motion in lemon, may very well decide the fate of her entire case before a single witness even steps foot in a courtroom. Under Rule 106, a judge has the authority to require that the jury be presented with the entirety of any communications, emails, texts, attachments, and other documents, rather than cherry-picked excerpts. The principle is straightforward. No half-truths, no misleading highlights, no selective storytelling. The jury must see the complete narrative to understand the context of every interaction. This rule has profound implications for Lively and her team. Headlines have been filled with sensational claims suggesting a coordinated smear campaign against Justin Baldoni and others. Out-of-context text messages and emails were presented in the media as proof of wrongdoing, with dramatic framing designed to shock and persuade the public. But when the unsealed documents are examined in their entirety, they reveal a very different story. There is not a single shred of evidence supporting the notion of a coordinated smear campaign. The supposedly damning texts were cherry-picked and misrepresented, stripped of the context that would clarify intentions and actions. For example, early media reports focus on a few heated exchanges and present them as evidence of an organized effort to undermine reputations. However, a closer look shows that these snippets were part of everyday professional communications. When the full threads are reviewed, the exchanges are far more mundane, routine, or even conciliatory. Misinterpretations or emotionally charged moments that were highlighted in isolation no longer appear incriminating when read in context. In fact, the broader communication suggests that many of these interactions were innocuous or professional in nature, directly undermining the narrative Lively's team initially promoted. The concept of cherry-picking evidence is crucial here. If only the most sensational parts of a conversation are shared, the audience, whether a jury or the general public, is presented with a distorted view of reality. It's like showing a single frame from a film and claiming it tells the whole story. Rule 106 prevents that. It ensures fairness, transparency, and the integrity of the legal process by requiring the full context to be made available to all parties. But Rule 106 is just one tool in a larger arsenal. The case also raises questions about tainted evidence, sometimes called the fruit of the poisonous tree. This legal doctrine, while more common in criminal law, applies in civil cases where evidence is improperly obtained. Allegations suggest that Stephanie Jones accessed Jen Abel's private phone and personal communications without consent, copied information, and passed it along to Blake Lively's team through a separate, potentially sham lawsuit filed by a company associated with Ryan Reynolds. Once evidence has been collected in a manner that violates privacy or bypasses judicial oversight, its integrity is inherently compromised. Even if Lively's lawyers later obtain official court-supervised copies, the origin of the material remains tainted. Chain of custody is critical in this context. Any break in the chain, from the initial collection, handling, or transfer, can render evidence unreliable. Baldoni's legal team can argue that from the very first moment the data was extracted, its authenticity was already in question. Without a verifiable chain of custody, there's no way to guarantee that the evidence wasn't altered, selectively edited, or otherwise compromised. Courts take this seriously because the integrity of evidence is a cornerstone of justice. If the evidence cannot be trusted, it cannot be presented to the jury, and the case may collapse entirely. Adding to this complexity is the issue of procedural fraud. If it is proven that the evidence was obtained through deceptive or sham legal processes, this is not a mere technical violation. It is a direct attack on the integrity of the judicial system. Courts have the power to impose Rule 37 sanctions in cases of misconduct during discovery. Rule 37 is essentially the nuclear option of civil litigation. It allows judges to exclude evidence, levy fines, order payment of legal fees, or even instruct juries to consider misconduct as evidence of bad faith. In extreme circumstances, these sanctions can completely cripple a case. For Lively, this could mean losing every single piece of evidence obtained through questionable means, collapsing her case before the trial ever begins. But it's not only about exclusion. If the judge denies a motion to exclude, Baldoni's team could use the full scope of the evidence to demonstrate that a sham lawsuit was orchestrated to obtain private communications improperly. This would shift the focus away from whether Baldoni did anything wrong to whether Lively's team abused the legal system, potentially devastating her credibility. It's a double-edged sword. Whichever way the judge rules, the implications are massive. The stakes are extraordinarily high because the public and media perception of the case is already shaped by dramatic headlines. In high-profile lawsuits, perception can influence reality. Social media, entertainment news outlets, and online commentary amplify partial information, often creating a narrative that can bias a jury even before trial. Judges and lawyers must actively work to ensure that these public impressions do not interfere with the fair administration of justice. Rule 106, motions in limine, and chain of custody arguments are all mechanisms to protect fairness against this backdrop of media scrutiny. Furthermore, this case highlights the dangers of elite individuals using legal systems to gain advantage. If high-profile figures can orchestrate clandestine lawsuits, extract evidence without oversight, and selectively release it to damage reputations, the implications extend far beyond this one case. Any journalist, professional, or private individual can find themselves targeted by similar tactics. The integrity of judicial processes and protections for privacy and fair procedure are at stake. What happens here may set a precedent for how courts handle digital evidence, improper discovery, and the use of legal processes by wealthy and influential parties. Another critical aspect is the way digital evidence is curated and presented. In the age of emails, texts, and instant messaging, it's easy for small excerpts to be taken out of context. A single heated sentence can appear far more sinister when stripped of the conversation's background, tone, or subsequent clarifications. Lively's initial filings focus on selective messages, framing them as proof of a coordinated campaign. Yet, a comprehensive review of the emails shows a more nuanced picture. Much of the communication was routine, professional, or benign. This is where cross-examination becomes essential. With access to full communications, attorneys can walk juries through entire chains of conversation, demonstrating how cherry-picking created misleading impressions that in effect. The upcoming pre-trial motions are the battleground where the case could be won or lost before any witnesses testify. They are a legal chess match in every sense of the word. Motions in limine, Rule 106 arguments, and potential Rule 37 sanctions collectively form a strategic web that can determine which evidence survives, how it is presented, and how the story unfolds for the jury. For Lively, this can mean the difference between a strong case and a complete collapse. For Baldoni and the Wayfair parties, it offers a chance to expose procedural abuse, challenge credibility, and protect their reputations. Ultimately, this is more than a celebrity legal dispute. It is a case study in digital evidence, procedural integrity, and the responsibility of courts to safeguard fairness in the face of high-profile litigation. It demonstrates a potential for powerful individuals to manipulate legal processes and how the judiciary uses rules like Rule 106, Rule 37, and motions in limine to maintain checks and balances. As the trial date looms, all eyes will be on the judge's rulings, the admissibility of evidence, and the chain of custody. The decisions made in these motions could shape not just this trial, but the legal landscape for future civil litigation involving digital communications, privacy, and high-profile parties. When the verdict finally comes, it will signify more than just a win or loss for Blake Lively or Justin Baldoni. It will set an important precedent about how evidence can be gathered, handled, and challenged in modern civil cases, especially when influential figures are involved. The stakes are massive. Careers, reputations, and the public's trust in the judicial system are all on the line. Whether Lively's evidence survives, is excluded, or triggers sanctions could reshape the narrative before a jury ever sees a single document. This is the final phase of a legal battle that began years ago behind the scenes, and is now poised to make waves in both legal and public spheres.
Justin, how are you feeling today?
What was the tension like in that room?
Why couldn't you guys settle yesterday?
Hope you guys stay nice and warm.
Thank you. But there's still a chance of settlement?
There's always a chance.
Is everyone required to come back tomorrow?
It'll be on a different matter.
But everyone will be back?
Yeah.
When will you resume the settlement conversation?
I don't know that we will.
You think this will go to trial? Brian, do you think this will go to trial?
Thanks. I do. I'm looking forward to it.
Imagine you're an employee who has already resigned and is preparing to walk out the door. Right before you leave, your employer demands you hand over the company-issued phone. There were never any policies restricting personal use. In fact, you were encouraged to use it personally. When you wanted to keep your same number, they even helped port it over and paid the monthly bill. Then suddenly, the day before your departure, you're called in, your phone and laptop are taken. A full digital forensic review is conducted to see whether you took company information or acted improperly. It's framed as routine protection for company, but you have no idea what's coming next as you're leaving. The chief of staff agrees to transfer the phone to a new device if you go to Verizon store. To make it happen, they request your passcode. You consent, but only for the limited purpose of completing the transfer. You spend 4 hours at Verizon. The transfer never happens. In fact, it never happens at all. 0.5 months later, your phone data appears in the New York Times. That's what reportedly happened to Gene Abel. A legal motion is expected soon, where Wayfair will finally address how this evidence was collected and whether the methods used cross serious legal lines. She claims the data was taken without consent. pulled not only from a physical phone, but also from personal iCloud backups and private messages, and then ultimately provided to high-profile figures involved in a dispute with one of her clients, including Blake Lively and her husband, Ryan Reynolds. Once the material was allegedly shared, the content of the device were no longer private. Out of a reported 316 megabytes of extracted data, potentially representing years of communications, only selected messages were highlighted. Those excerpts, she argues, were presented in a way that cast her client, and her colleague Melissa in the worst possible light. According to her account, the subpoena used to obtain the data stemmed from litigation that named no real defendant and involved no active judicial oversight. She contends the employer handed over the information without meaningful resistance, and she remained unaware of the scope of what occurred until much later. She now says she better understands the seriousness of the situation. California's Penal Code Section 502, the Comprehensive Computer Data Access and Fraud Act, prohibits knowingly accessing or using data from a computer system without authorization, even if the device was in company possession. She argues that using a passcode obtained for a limited purpose to conduct a broad forensic extraction could qualify as unauthorized access under that statute. Unlike the Federal Stored Communications Act, which focuses primarily on server access, Section 502 addresses copying or making use of data directly from a device. Blake has denied hacking, maintaining that access was limited to material available on the phone itself. However, forensic documentation referenced in court filings, including a Celebrite extraction report attached as an exhibit to Wayfair's summary judgment motion, reportedly indicates a full file system extraction involving approximately 316 megabytes of native message data. Such an extraction typically requires specialized forensic software and goes far beyond simply scrolling through visible text that a full file system extraction can replicate the device's underlying data structure, including system files, databases, and potentially recoverable deleted content, rather than just user-accessible messages. In practical terms, it is the digital equivalent of duplicating the entire contents of a home rather than glancing through a window. This process may capture raw data fragments, metadata, and store credentials, including keychain information tied to, say, passwords for email, streaming services, medical portals, and other accounts. While only a fraction of that material, reportedly around 122 pages, was ultimately produced or referenced, she argues the scope of the extraction itself raises serious privacy concerns. What she's describing is not just someone scrolling through a phone. It's the allegation that a complete forensic image of Jen's device was created, essentially a digital clone. With that kind of extraction, the argument goes, whoever possesses the data could potentially access usernames, save credentials, linked accounts, and deeply personal information spanning years of someone's life, all without that person's knowledge or meaningful consent. Advanced forensic tools, such as Celebrite, are designed to retrieve far more than what appears on the surface of a screen. They can pull data from third-party applications that typically restrict standard backups, including encrypted messaging platforms like WhatsApp, Signal, or Snapchat, depending on device state and permissions. They can also reconstruct location artifacts, sometimes referred to as location breadcrumbs, which may reflect where a device has traveled based on system logs and metadata, even if the user was not actively navigating with a Maps app at the time. Modern smartphones continuously generate background data tied to health tracking, Wi-Fi connections, Bluetooth pings, and GPS signals. A full file system extraction can aggregate those fragments into a detailed behavioral timeline to I end this account. The only credential voluntarily provided was a passcode, and that allegedly for the narrow purpose of facilitating a number transfer at a Verizon store. A passcode allows someone to unlock a device. It does not automatically grant informed consent to conduct a deep forensic acquisition of system-level data, email tokens, encrypted app databases, or store credentials. Forensic software can, in some circumstances, bypass ordinary user-facing security layers and access the underlying file architecture of the device. That's what makes this type of extraction qualitatively different from simply opening apps and reading visible messages. The claim is that the data pool went so deep it did not merely find information, it systematically extracted, indexed, copied, and preserved it. That includes a possibility of recovering deleted messages that remain in unallocated database space until overwritten. It can include metadata, timestamps, and fragments of communications the user believed were gone. If the device remained linked to iCloud or other synchronized services during that window, there are concerns about whether incoming data could also have been mirrored or captured. When challenged, the response on the opposing side has reportedly been that access was limited to what existed on the phone, not external cloud servers. But critics argue that distinction may be narrower in theory than in practice. A full file system extraction of a smartphone can effectively function as a mirror of the user's digital ecosystem because so much modern communication is cached, tokenized, or stored locally in database form. To put the scale into perspective, 316 megabytes of raw extracted data is not a handful of screenshots. Estimates suggest that amount of textual data could equate to roughly 150,000 to 200,000 pages of printed material, depending on formatting. Yet only about 122 pages were reportedly produced or highlighted. That disparity fuels the allegation that hundreds of thousands of private communications were sifted through to locate a comparatively small set of excerpts used to support a particular narrative. The extraction report also referenced attachments, over 100 index items, suggesting links to photos, videos, and voice notes stored elsewhere in the device's memory. That implies the review was not confined to text messages alone, but extended to multimedia files and other stored artifacts. In practical terms, critics liken the difference of glancing through a window versus dismantling the entire structure of a home to inspect every drawer, crawl space, and safe. There's also the matter of deleted content. Forensic recovery tools can analyze raw database structures to identify remnants of erased data. While that capability is commonly used in criminal investigations, it typically requires legal authorization, which brings up a comparison some have drawn to high-profile federal prosecutions, such as a case involving Joshua Duggar, where law enforcement needed a search warrant supported by probable cause before creating a forensic image of a computer. Only after judicial authorization could experts analyze deleted files and reconstruct digital evidence. Here, the criticism is that no such warrant or judicial guardrails were in place. Instead, the allegation is that a private party conducted what functionally resembles a law enforcement level search without court supervision. That's why references to statutes like California Penal Code Section 502 surface in the discussion, because that law addresses unauthorized access, copying, or use of computer data. Even if physical possession of a device is involved, beyond the technical and legal questions lies another issue: third-party privacy. Text message threads inherently involve multiple participants. If a device is forensically imaged, it does not just capture the owner's words, it captures the communications of everyone who interacted with them. Individuals such as Melissa Nathan, Katie Cassis, Brianna Costello, Justin Baldoni, Jamie Heath, Matthew Mitchell, and others were allegedly included in those extracted threads. Many of them may have had a reasonable expectation that their private messages would not be subjected to broad forensic review outside a judicial process. Point one, particularly sensitive allegation, involves Matthew Mitchell, who was reportedly still employed by Jones Works at the time the data was scraped. If accurate, that would mean internal employee communications were copied and potentially shared externally without his knowledge. The broader concern expressed is about proportionality and oversight. Smartphones today function as handheld computers, repositories of medical portals, financial records, therapy appointments, family photos, confidential client communications, and years of intimate conversations. A full file system extraction is not a minor intrusion. It is a comprehensive replication of someone's digital identity at a moment in time. Whether courts ultimately determine the access was lawful, consented to, or improperly obtained remains to be seen. But the debate underscores how powerful forensic technology has become, and how critical clear consent defines scope and judicial supervision are when that technology is used. She walked away from her job with no safety net, no backup plan, and no expectation that leaving would trigger something this extreme. That's part of what makes the situation feel so staggering to her. From her perspective, she resigned, tried to move on, and instead found herself at the center of a digital storm involving forensic extractions, celebrity litigation, and the exposure of deeply personal data. What she struggles to understand is why more of the individuals whose communications were swept up haven't pursued separate action. Katie, Bree, Jamie, Justin, all of their private messages were allegedly captured as part of the same data pool. Justin Baldoni and Jamie Heath have, in fact, filed counterclaims against Stephanie Jones, but critics dismiss those filings as deflection. The narrative pushed by some supporters has been simple. If there was nothing damaging in the messages, why object? Why sue unless you were afraid of what was found? But that framing, she argues, completely misses the point. The issue isn't whether embarrassing or controversial messages exist. The issue is whether someone should have had access to the entirety of a person's digital life in the first place. Privacy protections aren't reserved for the innocent or the flawless. They exist precisely to prevent unchecked intrusion. The idea that you wouldn't care if you had nothing to hide has long been criticized by civil liberties advocates as a dangerous oversimplification. Part of the alarm centers on the forensic tool reportedly used, Celebrite. Some jurisdictions have debated or restricted aspects of its use because of the depth of data it can extract. These tools are powerful by design. They are built for law enforcement and national security investigations, often deployed in cases involving terrorism, organized crime, or child exploitation. Their capability to bypass certain security layers and reconstruct deleted data makes them invaluable in criminal investigations. But that same capability raises profound privacy questions when used outside of tightly supervised contexts. She points out a principle that feels foundational. Just because something is technically possible does not mean it is ethically or legally justified. In criminal contexts, forensic imaging typically requires a warrant supported by probable cause. Judges set parameters. There are guardrails. Evidence is subject to suppression if obtained unlawfully. Here, she believes those guardrails were absent. There's also a separate California statute that has entered the conversation, the California Invasion of Privacy Act, CIPA. That law makes it unlawful to intercept or record communications transmitted between parties without consent if synced iMessages or group chats involving multiple participants were captured in real time, and if those participants did not consent. Critics argue that could raise serious questions under CIPA. The statute carries potential financial penalties per violation. Whether it applies in the specific factual scenario would depend on highly technical and legal determinations, but the concern underscores how complex the situation may be. Another layer involves iCloud synchronization. Smartphones continuously sync messages, photos, and other data to cloud servers. If a device remains linked to an active Apple ID, new communications can populate across connected devices automatically. According to filings she references, Jen did not change her iCloud password until months later, after litigation had begun, and after she had spoken with Apple support. During that interim period, uncertainty remains, at least in her telling, about whether additional extractions occurred or whether the device remained capable of mirroring incoming communications. The opposing legal team has reportedly maintained that they accessed only what was stored on the phone, not external cloud servers. But critics argue that distinction can blur in practice. When iCloud syncing is active, local device databases may contain mirrored content from the cloud. A forensic image of the phone could therefore include data that originated elsewhere but was cached locally. She also raises a scale issue again. 316 megabytes of extracted data. To a casual observer, that might not sound enormous in an era of gigabytes and terabytes. But when that data consists largely of text databases, attachments, and metadata, it represents an extraordinary volume of personal communication. Estimates converting that volume to printed pages suggest it could equal, well, over 150,000 pages. Yet only about 122 pages were ultimately produced or cited. That discrepancy fuels her belief that a vast ocean of private material was combed through to isolate a relatively small number of excerpts. The broader frustration is directed at courts' handling of related claims. When certain invasion of privacy, Stored Communications Act, or wiretapping arguments were dismissed, she felt the magnitude of the forensic intrusion was not fully appreciated. In her mind, this was not a minor discovery dispute. It was a foundational challenge to how evidence was obtained. She compares it again to federal criminal cases. When Homeland Security or other agencies conduct forensic imaging of computers in cases involving child sexual abuse material, they must secure a warrant. They must articulate probable cause. They must define the scope. Only then can experts comb through deleted files and reconstruct fragments. That process is structured precisely because of how invasive it is. Her fear is that allowing such evidence to proceed to trial without first resolving the legality of its acquisition could set a troubling precedent. If courts permit litigants to rely on data obtained through questionable methods, she believes it risks incentivizing aggressive digital intrusions. Evidence rules exist not just to uncover truth, but to deter misconduct and how that truth is gathered at the same time. It's important to acknowledge that allegations are not findings. Courts evaluate facts, consent, contractual agreements, device ownership, company policies, and statutory interpretation in detail. What feels egregious to one side may, after legal scrutiny, be deemed permissible under employment agreements or digital access doctrines. The final outcome depends on judicial determinations that weigh competing narratives and technical evidence. Still, the emotional toll is evident. She describes embarrassment, public ridicule, and the sense that private communications were weaponized. Smartphones today contain therapy appointments, medical discussions, family crises, confidential client strategies, and intimate conversations. When that ecosystem is copied wholesale, the impact goes beyond litigation strategy. It touches identity and trust. Her hope is that appellate courts, if necessary, will take a fresh look at the legal theories. If evidence was obtained improperly, she believes it should be excluded. If statutes were violated, she believes accountability should follow, civilly or even criminally. She worries that without meaningful consequences, others could face similar intrusions. Ultimately, this controversy sits at the intersection of celebrity conflict, employment disputes, digital forensics, and evolving privacy law. It highlights how much of modern life is stored in devices small enough to fit in a pocket, and how high the stakes become when access to those devices is contested. Whether the courts view this as aggressive litigation strategy or unlawful digital overreach remains to be seen. But the debate underscores a growing societal question. In an era where our phones are extensions of ourselves, where should the legal boundaries
I suffer from toxic masculinity. Absolutely not. So it was not something where we're like, let's have like the most successful singer of all time, in our film. It was just not something we were considering, but it worked so well in the trailer that I was like, we gotta put this in the movie. And there was
Blake Lively and Stephanie Jones are now scrambling to avoid accountability connected to Van's lawsuit, which critics claim was sham litigation designed to obtain the contents of Jen Abel's phone. Abel served as a publicist for Wayfarer Studios, Justin Baldoni, and Jamie Heath. According to the allegations, information from that phone eventually reached the New York Times, after which the story quickly spread. The narrative that followed suggested there had been a smear campaign organized by Wayfarer against Lively, supposedly to damage her reputation in case she ever spoke publicly about alleged misconduct connected to the film. It ends with us, "If you didn't see my video from yesterday, make sure to check it out." In that video, I discuss Ryan Reynolds' alleged behavior on the set of Boatneck involving Matthew Lawrence. According to the story, an extra claimed Reynolds added unscripted and unchoreographed kissing scenes, allegedly using the set environment to repeatedly kiss her throughout the day. Some observers say the situation mirrors the accusations Blake Lively has made against Justin Baldoni. I'll place that video link in the description so you can watch the full breakdown. Meanwhile, the situation surrounding this case shows signs of desperation as they attempt to avoid potential consequences. Several procedural moves appear aimed at delaying or blocking the possibility that the judge could issue a ruling unfavorable to Stephanie Jones, particularly regarding her motions to dismiss the claims filed against her by Wayfarer Studios. When I reviewed the timeline closely, something important stood out. On October 3rd, 2025, Judge Lewis Lyman partially granted and partially denied Stephanie Jones' motion to dismiss. In that ruling, the judge determined that Jennifer Abel's claims under California Penal Code Section 502 could plausibly proceed toward trial. The judge specifically noted that Jones' argument that Abel had not alleged a scheme or artifice to defraud required under the statute was not convincing. The statute itself clarifies that liability can arise when someone accesses a device or data either to carry out a fraudulent scheme or to wrongfully control or obtain information. The judge explained that Abel not alleging a fraudulent scheme does not mean she failed to allege wrongful control or access to her data. According to the court, the allegation suggested it was plausible that the Jones parties accessed Abel's phone data without authorization. Stephanie Jones had argued that the phone belonged to the employer and therefore she had the right to access its contents. However, California law does not automatically grant employers unrestricted authority over data stored on employee devices. The judge pointed out that Abel's counterclaims included communications showing that shortly after she left Jones' works, messages from her phone appeared to have been circulated internally within the office. The ruling also referenced evidence suggesting that copies of emails and text messages were shared among Jones' works employees and eventually made their way back to Abel. This indicated that the data extraction may have occurred before the Vans and lawsuit even existed, raising further concerns about how and why the information was obtained. Jones also argued that Abel had not shown the phone was accessed in a way that bypassed technical barriers or security protections. But the judge explained that this interpretation of the law comes mainly from court decisions interpreting the statute rather than from the statute's actual wording. He referenced a case of Facebook versus Power Ventures, which discussed situations where technical skill was used to bypass security barriers. In that case, users allowed a third-party service to manipulate their Facebook content. The judge explained that the circumstances in Abel's allegations were quite different. Here, the claim is that data on Abel's phone was accessed and used without permission. Because of that distinction, the court said it did not make sense to apply the same analysis regarding technical barriers or terms of service violations. Instead, the question is whether the defendants knowingly accessed or used data without authorization. At the pleading stage, the judge determined that Abel's allegations could reasonably support such a claim under California Penal Code Section 502. Since that ruling, Stephanie Jones has been attempting to amend filings and adjust her legal strategy. The court's earlier decision essentially rejected the argument that she automatically had the right to search through Abel's phone. That alone creates a serious issue as the case moves forward. This also connects directly to Wayfarer Studios' counterclaims. Wayfarer argues that Jones Works violated contractual obligations tied to confidentiality. Their first cause of action alleges breach of contract. According to the agreement between Wayfarer and Jones Works, Wayfarer could share confidential, proprietary, or sensitive information about its business, clients, or partners. Under the contract, Jones Works was required to use reasonable and diligent efforts to keep that confidential information protected. The agreement allowed disclosure only when necessary to fulfill obligations under the contract or when sharing with legal representatives. In other words, the company was expected to safeguard that information and limit access strictly to legitimate business purposes. Blake Lively and Stephanie Jones are now facing increasing scrutiny as legal developments surrounding the Vans and lawsuit continue to unfold. The dispute centers around allegations that the litigation itself was used as a strategy to obtain access to the contents of Jen Abel's phone. Abel previously worked as a publicist connected to Wayfarer Studios, and individuals associated with the production of It Ends With Us. The information retrieved from that phone allegedly circulated among various parties and eventually reached media outlets, which helped shape a broader narrative surrounding the controversy. AT, the center of the legal battle, is a confidentiality agreement between Wayfarer and Jones Works. Under that agreement, Jones Works was permitted to receive sensitive information from Wayfarer strictly for the purpose of performing its contracted public relations services. The contract clearly stated that such confidential information could not be used for any purpose beyond the performance of those services unless disclosure was required by law or ordered by a court of competent jurisdiction. The agreement also included language clarifying that Jones Works would not be liable for disclosures made by third parties, provided those third parties did not obtain the information because of a breach by Jones Works itself. In other words, if confidential information was leaked or shared due to a violation of the agreement by Jones Works, responsibility could still fall back on them. This contractual framework becomes especially important when considered alongside the court's earlier ruling in Jennifer Abel's case. The judge determined that Abel had plausibly alleged that Jones Works accessed and used the content of her phone before any subpoena existed. According to the allegations, information taken from the device was circulated internally among colleagues and possibly shared with outside parties. The court indicated that, at least at the pleading stage, it was reasonable to infer that the phone may have been accessed without proper authorization. The judge stated that the allegations suggested Jones Works may have entered the phone without consent or permission and then used the information in a way that harmed Abel. Because of this finding, the issue now intersects directly with the contractual obligations Jones Works had toward Wayfarer. The contract required that confidential information be protected and not disclosed to third parties unless legally compelled. If information was accessed and distributed without authorization, that could potentially represent a breach of those contractual duties. Wayfarer's counterclaims argue precisely that point. They claim Jones Works and Stephanie Jones violated the confidentiality provisions by voluntarily disclosing sensitive information to third parties. According to the allegations, those third parties included individuals such as Leslie Sloan as well as Blake Lively and Ryan Reynolds. The claim goes further, stating that if those individuals received confidential information, it could only have happened because of a breach of the confidentiality agreement. Wayfarer argues that the disclosure was not authorized and that it was not corrected or cured within the time allowed under the contract. As a result, Wayfarer asserts that it suffered damages, the amount of which would ultimately need to be determined at trial. The damages claim rests on the argument that confidential information was mishandled and that the breach directly harmed the company and its associated partners. In addition to breach of confidentiality, Wayfarer also alleges breach of contract related to the quality and manner of services provided. Under the agreement, Jones Works was retained to provide strategic communications and public relations support in a professional manner consistent with goals established jointly by both parties. Wayfarer claims those obligations were not met. Instead, they allege that Jones Works failed to perform services professionally and acted in ways that undermine the agreed objectives. According to the filing, this conduct represents another breach of the contractual agreement. Another key claim involves breach of the implied covenant of good faith and fair dealing. This legal principle exists in most contracts and requires both parties to act honestly and not intentionally undermine the agreement's purpose. Wayfarer argues that it fulfilled its own contractual obligations, but that Jones Works engaged in conduct that deprived Wayfarer of the benefits it expected from the contract. Specifically, they allege that confidential information was intentionally provided to hostile third parties in a way designed to damage Wayfarer and individuals associated with the company. They further claim that this conduct went directly against Wayfarer's interests and disrupted the working relationship that the agreement was supposed to protect. by allegedly feeding internal information to outside parties. The company argues that Jones' works prevented Wayfarer from receiving the benefit of his bargain. All of these claims became more significant after the judge's earlier ruling in Jennifer Abel's case. In that decision, the court concluded that Abel had sufficiently alleged that her phone was accessed without permission and that the data on it may have been used improperly. The judge emphasized that, at the pleading stage, those allegations were strong enough to move forward under California Penal Code Section 502. This statute addresses unauthorized access to computers and electronic data. The ruling also referenced precedent from the Ninth Circuit, which has held that even accessing a database with a valid password can violate the law if the information is later copied or used improperly. In other words, the legality of access does not only depend on the password itself, but also on whether the use of the information was authorized. Applying that reasoning, the judge determined that Abel's allegations plausibly suggested that the Jones parties knowingly accessed and used data without permission. Abel claimed that she only provided her passcode temporarily to assist with transferring her phone number. According to her allegations, that limited access was later expanded without her consent. She claimed the Jones parties retained access to her iCloud account and could continue reviewing information stored on the device even after she left the company. The allegations also stated that Jones Works had possession of the phone itself at one point, which could have allowed them to bypass certain security protections. Abel further argued that using a personal phone in a public relations job is common practice, and that the company had no formal policies allowing them to monitor personal devices. Because of that, she said she reasonably expected to retain exclusive control over her private data and accounts. She also stated that she would not have turned over the phone without making arrangements to secure her information if she had known the company might access it. Taken together, the court concluded that these allegations could plausibly support claim for relief under the relevant law. At the pleading stage, that was enough to allow the case to proceed further. That conclusion created a significant legal challenge for Stephanie Jones and her company. By acknowledging that Abel's claims were sufficiently supported at this stage, the court opened the door for deeper scrutiny of how the phone was accessed and how the information may have been used as the litigation continues. Those findings are likely to remain central to the broader dispute involving Wayfarer, Jones Works, and the individuals connected to the case. The court determined that the factual allegations presented in Jennifer Abel's case were sufficient, at least at the pleading stage, to support the claim that Stephanie Jones accessed Abel's phone without proper authorization. According to the court's interpretation of the allegations, Jones did not have a clearly defined policy that allowed her to monitor Abel's personal device, nor was there evidence that Abel had granted broad permission for such monitoring. The judge indicated that, based on the facts alleged, it was plausible that Jones accessed a phone without authorization, extracted data from it, and then shared that information with others. This finding becomes significant when considered in relation to the broader dispute involving Wayfarer and Jones Works. If the judge's reasoning in Abel's case carries over the claims raised by Wayfarer, it could strengthen several of the company's allegations. Wayfarer argues that confidential information entrusted to Jones Works was improperly accessed and then shared outside the boundaries established by their agreement. The defamation claim within the case may present additional challenges because defamation typically requires a specific statement that can be identified and evaluated in court. Without a clearly documented statement that was communicated to third parties, proving defamation can be more difficult. However, the other claims raised by Wayfarer, such as breach of contract, breach of the implied covenant of good faith and fair dealing, and violations of confidentiality obligations, could potentially stand on stronger footing if the underlying allegations regarding unauthorized access to Abel's phone are accepted by the court. For a public relations professional, the implications of such findings could be particularly serious. PR firms operate largely on trust and confidentiality. Clients rely on their communications advisors to handle sensitive information responsibly and to protect internal details that could affect reputations, business relationships, or legal matters. If a court were to determine that a PR firm accessed private information without authorization and used in ways that harm the client or employee, that could significantly damage the firm's credibility in the industry. Such a finding would raise concerns for current and future clients who might question whether their own confidential information could be mishandled. In industries like entertainment and media, where reputations and narratives are often closely managed, confidentiality is considered essential. Any suggestion that a communications professional weaponized information obtained through a professional relationship could undermine the foundation of that trust. The situation became even more complicated after Abel amended her complaint. In a revised filing, several federal claims were removed, and the focus shifted to a smaller set of claims, including promissory fraud, conversion, and alleged violations of California Penal Code Section 502. That statute addresses unauthorized access to computers and electronic devices and is often used in cases involving improper access to digital data. The inclusion of the Section 502 claim is particularly significant because the judge had already indicated that the allegations surrounding unauthorized access to Abel's phone were plausible enough to proceed beyond the early stages of litigation. As a result, the legal exposure connected to that claim may be difficult to eliminate through a motion to dismiss. After the amended complaint was filed on October 31st, Jones responded by attempting to expand the litigation in several directions. Among other things, she sought to compel testimony from additional individuals and attempted to add new claims involving other parties. These included allegations related to the recording of a phone call and claims suggesting that certain individuals were involved in creating online smear campaigns. By introducing new allegations and additional parties, the legal process becomes more complex. Expanding a case in this way can sometimes lead to delays because the court must evaluate whether the amendments are appropriate and whether the new claims meet procedural standards. If the judge allows such amendments, the case may effectively reset in certain respects, giving both sides an opportunity to revise filings and respond to the updated claims. From a procedural standpoint, this type of development can significantly slow down the timeline of a case. For example, if amendments are approved, the opposing parties may need to file updated complaints or responses. That could be followed by another round of motions to dismiss or other pretrial motions, each of which requires time for a briefing and court review. Critics of the strategy sometimes argue that such amendments can function as a delaying tactic, particularly if they are introduced long after the original complaint was filed. However, courts also recognize that litigation often evolves as new information emerges, and judges typically evaluate whether amendments serve legitimate legal purposes. I end the situation. The dispute remains in an active stage where the court has not yet made final determinations regarding liability. Instead, the judge is focused primarily on whether the claims have been adequately pleaded so that they may proceed to the litigation process. At the same time, the broader public narrative surrounding the case continues to shift as legal documents, filings, and rulings become available. When court records are unsealed or new motions are argued in hearings, the information can quickly influence media coverage and public discussion. Observers note that this dynamic can affect how stories about high-profile disputes evolve over time. Early reports may focus on one version of events, while later court filings or rulings introduce additional details that reshape the narrative. In complex cases involving multiple parties and competing claims, it is not unusual for public perceptions to change as more information becomes available. The current phase of the litigation appears to revolve around procedural questions, such as whether amendments will be allowed, whether claims will survive motions to dismiss, and how the court will interpret the contractual and statutory issues at stake. Those decisions will likely determine how the case moves forward and which claims ultimately reach trial. If the case proceeds further, the court may eventually examine the underlying evidence in greater detail, including communications, documents, and testimony related to the disputed access to Abel's phone and the alleged sharing of confidential information. At that stage, the legal analysis would shift from evaluating whether claims were plausibly alleged to determining whether they can be proven with evidence. Until then, the dispute remains part of an ongoing legal process in which each side continues to argue its interpretation of the facts and the law. The outcome will ultimately depend on how the court resolves these competing claims and how the evidence presented during the litigation supports or contradicts the allegations raised by the parties involved.
Because the Green Lantern, you would think, okay, this is a movie about a guy with a magical ring and a magical, he wears green spandex. What? I've never heard of this superhero. But then when you're doing your research, you know, it's one of the longest comics of all time. It's actually a really amazing story, and being on the set with Martin Kaye, Peter Sarsgaard, and Tim Robbins, and Ryan, you know, he had such a high level, you know, high standards, and there was so much quality on the set that you really saw, wow, I'm making a good film. I'm not just making a big box office franchise movie.
Should I sue Blake Lively? I'm honestly starting to wonder, because a document filed in court is accusing me of being involved in some kind of coordinated campaign. One of her so-called experts even decided, without ever speaking to me, that I was part of it. According to them, I'm supposedly tied to a digital manipulation effort simply because I reported on the lawsuit and posted commentary about it online. That I end the filing. They claim that influencers who posted criticism of Lively were being coordinated by the defendants after she filed her lawsuit. They specifically say that evidence suggests certain social media posts attacking her were part of a larger strategy. Point one example they mention involved the influencer and journalist Sage Steele. The document alleges that she developed a video together with several people connected to defendants, including individuals they name as Steve Sarwitz, Jamie Heath, Jennifer Abel, Justin Baldoni, and Melissa Nathan, along with Baldoni's attorney, Mr. Friedman. According to the filing, text messages dated January 3rd, 2025 allegedly showed discussions about how to make a video that could go viral. In the messages, Friedman reportedly said Sage Steele was on copy and that the group needed to begin a video that was spread organically online. The group then supposedly brainstormed points she could include in order to challenge or discredit Lively's claims. But remember, this was after the lawsuit had already been filed. From my perspective, it looks like a defense team preparing arguments for the public conversation surrounding the case. The filing then references another set of text messages from 3 days later. It claims Steele sent a draft video to the group asking for feedback and later shared an updated version. The document says suggestions included discussing how public accusations can destroy the lives of people who don't have bodyguards or gated estates, and also referencing the so-called Little Bump interview. Friedman allegedly suggested she explained that she became interested in the case not simply because her lawyer was involved, but because once she started researching the coverage, she found what she believed to be irresponsible or inaccurate reporting. The message reportedly suggested comparing the situation to the Duke Lacrosse case, pointing out how a rush to judgment in that case damaged reputations for years. The advice was to emphasize looking at the facts and to point out that Baldoni's team had released text messages publicly, suggesting they had nothing to hide. From my perspective, none of that seems unusual. If a legal team talks to media figures or commentators about their side of the story, it's not very different from an influencer interviewing someone connected to a case. And all of this supposedly happened after Lively had already taken her claims to the New York Times. The filing continues by stating that Steele eventually published a video on January 7th across several social media platforms, including YouTube, Instagram, TikTok, X, and Facebook. She also released an audio version on podcast platforms in that video. The document says she criticized Lively and the reporting in the New York Times. It claims she repeated several points discussed in those earlier conversations, including mentioning her personal interest in the conflict between Lively and Baldoni, referencing her relationship with Friedman, discussing the Little Bump interview, and talking about text messages released by Baldoni's team. She also reportedly said she believed Lively was abusing her power, which she argued could end up harming other women. Let me be very clear about something here. I never even watched that video. I didn't even know who Sage Steele was until I read this document. I had heard her name mentioned in passing, but I had no idea who she actually was. Despite that, the filing suggests that people like me helped circulate the video and amplified the supposed campaign. But that's simply not true. The document then tries to show the alleged impact of this so-called retaliation campaign by pointing to activity on platforms like TikTok. It references a post captioned, "Sorry, but Blake Lively has always given mean girl vibes." The video featured a compilation of interviews from throughout Lively's career and reportedly received around 12.1 million views. One commenter wrote that Blake Lively was an awful human being and a classic mean girl who thought she was better than everyone else. Another comment described her as the ultimate mean girl and received more than 12,000 likes. Many other users echoed similar opinions. Some said they were surprised to see behavior they considered rude or dismissive in old interviews. Others accused her of bullying. One comment even referenced an incident involving Catherine, Princess of Wales, claiming Lively mocked her during a time when the princess was undergoing cancer treatment. That situation actually happened earlier in May 2024 when Lively made a post online that later required an apology. Another commenter pointed to a particular interview included in the compilation video, saying it was sad because the interviewer appeared to be trying very hard to remain professional while Lively seemed dismissive. There was also another viral video titled "The Downfall of Blake Lively and Ryan Reynolds," which discussed newly released evidence in the case. That video reportedly received around 7.4 million views and nearly 15,000 comments. Several of those comments continue criticizing Lively's behavior and character, further fueling the ongoing debate around the case. Commenters on the post repeated the idea that Blake Lively is a bully, and those comments received tens of thousands of likes. But here's what I find interesting. Do people actually understand how social media works? When a topic starts trending, the internet tends to jump in and do what it always does. People pile on with their own opinions, experiences, and long-held impressions. In this case, many users seem to bring years of feelings about this woman into the conversation. Personally, I didn't know anything about Blake before all of this. I never watched Gossip Girl, and I've never seen one of her movies. The only thing I knew was that she was married to Ryan Reynolds. And honestly, I didn't like Ryan Reynolds either, mostly because of his reputation back in the 2000s. To me, everything he does now feels very manufactured, like an image that was carefully rebuilt over time. I remember how he was perceived back then, and that impression stuck with me. But even with that, I didn't care much about Ryan or Blake. Again, I didn't watch their films, and they weren't really on my radar. Some commenters online suggested that Blake may simply be used to intimidating people, and finally ran into someone who refused to back down. One comment that stood out said, "Her ego will destroy her and she'll blame everyone else." That comment alone received around 44,000 likes. Another user wrote that false accusations make things worse for women because they damage credibility overall. That comment received about 21,000 likes. Other commenters argued that TikTok, as a platform, had essentially turned against Lively. One person wrote, "Blake is screaming, crying, throwing up that TikTok did not go her way," and that comment received around 248,800 likes. Another user wrote, "Blake hates TikTok so much right now," which gathered roughly 52,000 likes. One of the accounts that posted these videos, called Better Company, is a well-known influencer account on TikTok with more than 1.6 million followers. Other major influencer accounts across TikTok, YouTube, and Instagram also shared content about the controversy surrounding Lively and the broader discussion about the film It Ends With Us. The filing even mentioned accounts like an influencer with over 160,000 Instagram followers and the YouTube channel Popcorn Planet, which has about 946,000 subscribers. There's even a footnote referencing these accounts. According to the document, both accounts have posted a significant amount of content discussing Lively and the promotion of It Ends With Us, often presenting her in a negative light. Much like the Better Company account, the comments under their posts also repeat the same narrative that Lively behaves like a mean girl or a bully. For example, one comment said, "She seems like a mean girl bully who thinks she's better than everyone else." Another comment under a January 2025 video on the Popcorn Planet channel said, "Blake is a mean girl who weaponizes incompetence and then plays the victim. She is not complicated." Now here's the strange part. I can actually show the post they claim they're citing from my account. What's extremely odd is that the link they included leads to a post that doesn't even exist on my page anymore, or at least it doesn't appear as a normal post. It looks more like a story than a permanent upload. I honestly don't know what they were referencing. What's even stranger is that they focus heavily on that one supposed post while completely ignoring another post I made on January 25th, 2025. In that post, I wrote directly, "Dear Blake and Ryan, I organically do not believe you, and I am not being influenced or coerced by anyone. This is simply the result of your own actions." I made it very clear that my opinion was my own. I explained that when people do something wrong, they should take accountability and apologize. I criticized the way a film dealing with domestic violence was promoted as if it were a romantic comedy or feel-good story. I argued that minimizing the message of a film through heavy promotion of alcohol brands and hair care products sends a wrong message. I also said that failing to use a large platform to speak up for people affected by domestic violence was disappointing. I criticized the use of derogatory language toward cast members and colleagues. I questioned the decision to attempt to take control of production without proper rights. I also mentioned allegations about manipulating the narrative around the film, controlling on-set dynamics, and publicly mocking other people involved in the project. I criticized what I believed were false accusations of smear campaigns. I also brought up past controversies involving connections to figures like Harvey Weinstein and working with directors like Woody Allen. I mentioned issues like getting married at a plantation venue, accusations of fat-shaming a reporter, and complaints from journalists about rude behavior during interviews. I even referenced claims that powerful friends, including Taylor Swift, were sometimes pulled into public narratives around controversies that my point in that post was simple. Being attractive, wealthy, and famous does not excuse questionable behavior. I said they should take accountability and apologize. That I concluded by saying that the backlash happening online appeared to be organic. In my view, people were reacting to their own perceptions of events. I argued that blaming others for criticism while refusing to acknowledge mistakes only makes the situation worse. That was one of the very first posts I ever made about Blake Lively. Yet the filing focuses almost entirely on a different post, and one that is not even correctly linked. From that, they jumped to the conclusion that I must somehow be part of a coordinated retaliation campaign. But the reality is much simpler. I made a post about a topic that was trending online, about a lawsuit that had already been filed. I read court records, looked at the information available, and came to my own conclusions. The filing also states that negative associations amplified by this alleged retaliation campaign continued shaping discussions as new information emerged after Lively filed her lawsuit. They even claimed the impact could be seen on Reddit. According to the document, New subreddit supportive of Justin Baldoni appeared after the lawsuit was filed, suggesting that the online conversation continued evolving as more details about the case became public. They claimed that these online spaces were created to recirculate and discuss negative associations about Blake Lively. And honestly, when I read that, I couldn't help but laugh a little. One example they pointed to was a subreddit called Team Justin Baldoni. If you've ever actually visited that subreddit, you'd know how unbelievably mild it is. It's honestly one of the most benign communities I've ever seen online. The moderators there are some of the nicest people you could possibly interact with on Reddit. I'm serious. They're polite, respectful, and they keep discussion civil. Compared to a lot of other corners of the internet, it's actually one of the most well-moderated and friendly subreddits I've ever participated in. According to a report, that subreddit was created on January 14th, 2025, and has around 14 to 15,000 subscribers. The stated purpose of the group is simply to support Justin Baldoni, but the report tries to frame it as something more sinister. They claim that many of the top posts in the subreddit are negative toward Blake Lively rather than focus on Baldoni himself. But that's not exactly surprising when you think about it. If someone files a lawsuit against a public figure, naturally the conversation around that lawsuit is going to include discussion of the person bringing the claim. You can't sue someone publicly and then act shocked when people talk about it. Another thing that really surprised me was that the report even cited posts made by some of my friends. One of the accounts mentioned is someone known online as Totally Texas. I don't actually know whether that person is a man or a woman. We've never met in real life. But what I can say is that they're one of the most thoughtful and respectful creators I've seen covering this situation. Their content is incredibly organized. They often summarize long videos, so people who don't have time to watch the full thing can still understand what's happening. Their posts are objective. They don't insult people. They don't call names. They're not cruel or aggressive. Yet somehow, simply participating in a discussion about a lawsuit or having an opinion based on information that is publicly available is now being labeled as participation in a smear campaign. And that's where things start to get really strange, because at the same time that Blake Lively claims all of this discussion is damaging her reputation, she also filed a lawsuit that triggered the conversation in the first place. My question is simple. If someone truly wants to protect their reputation, why file a lawsuit that generates massive public attention unless you're confident in your claims? Here's the part that is really shocking to me. In order to claim damages, this report essentially tries to treat the impressions of social media posts as financial losses that she should be able to recover in court. So according to this logic, if I ever said that I believe Blake Lively behaved like a bully or a mean girl, that opinion is now being used as supposed evidence that I was part of a coordinated smear campaign, and therefore somehow she should receive money because of it. But the reality is that my opinion had absolutely nothing to do with any campaign or coordinated effort. I formed my opinion based on her own words and behavior. I watched interviews. I looked at public statements. I read the court documents. And when I say I read them, I mean I read every single court document related to this case. Anyone who has followed my coverage knows that we discussed this lawsuit extensively. I've spent countless hours reviewing filings, analyzing statements, and trying to understand the full context of what happened. Whenever I express an opinion, I make it very clear that it is my opinion. But now even simply reporting on the lawsuit itself is being used as supposed proof that creators like me were somehow part of a campaign. The report actually includes a chart that attempts to calculate the number of impressions generated by posts that they claim are defamatory. These impressions are then converted into supposed monetary damages. And honestly, some of the examples they included are almost unbelievable. They listed outlets like Business Insider and Daily Mail publications that were simply reporting on developments in the lawsuit. Some of the articles they referenced weren't even critical of Blake Lively. They were just covering statements made by family members or discussing updates in the case. They also included Instagram posts, commentary videos, and social media discussions from people who were simply reacting to information that was already public. Yet all of those impressions are being added together and assigned a financial value. Here's another detail that stood out to me. The report specifically mentioned my page and my name. They went out of their way to highlight me. But when you actually look at the chart where they calculate impressions and damages, not a single one of my posts is listed at MY content, doesn't appear anywhere in the totals. They included creators like Perez Hilton, the H3 podcast, Megan Kelly, No Filter with Zach, Crazy Karen, and even commentators like Ben Shapiro. Apparently, under this theory, if you are in mainstream media or you report on trending legal news, you're automatically part of a smear campaign, which makes absolutely no sense. They even claimed there were 116 million impressions related to these discussions across platforms like YouTube, X, Facebook, and Instagram. The report breaks this down into categories like YouTube influencers, X-influencers, Facebook influencers, and Instagram influencers. And then they assign massive monetary values to these numbers. For Instagram alone, they claim damages of around $7.9 million based on a CPM of $15 per thousand impressions. That is completely unrealistic. Very few creators actually earn anything close to $15 CPM on Instagram. For YouTube, they claim a CPM of $45 per thousand impressions, which is even more absurd. Most YouTube creators know that CPM rates vary widely and rarely reach numbers like that consistently, as the entire financial calculation behind these supposed damages seems wildly inflated. But here's the final twist that really caught my attention. Despite mentioning my name in the report, none of my YouTube videos appear anywhere in the charts listing creators whose impressions supposedly cause financial harm. Not one. That's particularly interesting, because I was actually subpoenaed in connection with this case. And I noticed something else as well. Several creators who were subpoenaed also do not appear in these charts, which raises a very obvious question. If my content supposedly contributed to this massive smear campaign, why isn't it included in the very charts they're calculating the damages? My lawyers made it clear that I had no involvement in any coordinated campaign. In fact, after we pushed back legally, Blake Lively's team ultimately withdrew the subpoena before we filed a motion to quash it. I also went public and exposed what was happening, including the fact that they were attempting to obtain my bank account information as part of their request. And so the real question becomes this. If they already knew I was involved in any campaign, why was my name singled out in the report at all? The strange part is that even though my name appears in the report, none of my actual links are included as proof of damages. Think about that for a moment. If my content supposedly contributed to this massive smear campaign, why wouldn't they include the posts themselves in the damages calculations? It simply doesn't make sense. And to be clear, they didn't name everyone involved in the broader online discussion either. The report only calls out a handful of people. They mention commentators like Megyn Kelly, online creator Perez Hilton, and political commentator Candace Owens. They also reference channels like Popcorn Planet. Beyond that, they cite anonymous online comments that could have been written by literally anyone on the internet. Many of them likely weren't written by any of the creators being mentioned in the document at all. But when the report discusses prominent YouTubers and Instagram creators, there are only a few names singled out. Apparently the list includes Andy, myself, and a couple of other content creators. Why those specific people? I honestly have no idea. That IT just doesn't add up. If the claim is that there was some coordinated campaign across social media, then why are only a few individuals named while hundreds of others who discuss the same topic are ignored? The
court case all around it and a lot of speculation.
It is, but it's getting easier to separate it because I do look at the success of it. Like opening week, we just were all so shocked at how much readers showed up for it and how well it did and how much it resonated. Like I am so proud of that movie. I think the actors, the director, everyone did such a good job making it that, I have to look at everything else separate from the film, from the book.
Colleen Hoover has somehow managed to avoid nearly all of the accountability surrounding the film adaptation of It Ends With Us. Meanwhile, she has another movie on the way called Reminders of Him and a fourth adaptation, Verity, scheduled to release later this fall. During a recent interview on the Today Show podcast hosted by Jenna Bushhager, things got particularly interesting. Jenna appeared to be a massive fan of Colleen Hoover, which honestly surprised me. Considering Jenna and her sister are highly educated, I would have expected a bit more discernment when it comes to literary taste. During the interview, Colleen spoke extensively about several of her projects. She talked in detail about the upcoming film Reminders of Him. She also spent time discussing Regretting You, another project in development, and she even spoke about Verity, which is scheduled to be released later this year. However, when the conversation shifted toward End With Us, everything suddenly changed. When asked about the controversy surrounding that adaptation and whether it affected her feelings about the book, she became extremely careful with her wording. The question itself was interesting because it asked whether the drama surrounding the film had impacted her art. And honestly, calling Colleen Hoover's writing art feels like a stretch. But putting that aside, what stood out the most was her refusal to say anyone's name. She would not mention Blake Lively. She would not mention Justin Baldoni. She wouldn't mention the director or the actors involved with It Ends With Us at all. Yet during the same interview, when discussing her other projects, she freely named directors and collaborators without hesitation. Instead, when talking about It Ends With Us, she spoke in vague terms. The only thing she really emphasized was that the movie had been a financial success. And I still find it strange to celebrate financial success when the underlying subject matter of the book deals with such heavy themes. But regardless, she now appears to be walking back comments she made back in November, that time, in November 2025. She said she felt embarrassed by the book. In an interview with Elle magazine, she described the entire situation surrounding the film as unfortunate and even referred to it as a circus. She was clearly referencing the very public feud between Lively and Baldoni. She said that the controversy had overshadowed both the book and the movie so much that she felt uncomfortable even saying she was the author at End With Us. She also explained that she could no longer recommend the book the way she once had, because the lawsuit drama had pulled attention away from the actual story. According to her, she wanted to distance herself from the negativity and avoid contributing to the back and forth conflict. But looking back at everything now, it raises a serious question. How does someone essentially light the fuse, set off the explosion, and then walk away untouched? Because that's what it looks like happened. While the fallout has affected others, Colleen Hoover appears to have come through it without consequence. Meanwhile, Blake Lively reportedly hasn't taken on new work recently, and Justin Baldoni has largely stayed out of the public spotlight. Yet Colleen continues promoting new adaptations and announcing additional projects without interruption. That's the part that really confuses me. It genuinely feels like she's trying to present herself as someone who had no involvement in the drama at all. But we've already seen the unsealed documents. And those documents include the messages she sent to Blake, as well as the things she said about Baldoni. Some of those comments were incredibly harsh, and yet none of the interviews she's doing now actually address the core of the controversy. Instead, they circle around it. The questions stay soft. The responses stay vague. It almost feels like Colleen Hoover doesn't really give interviews anymore. She does publicity appearances. And there's a huge difference between the two publicity appearances usually involve friendly hosts and carefully controlled conversations. They tend to feature soft questions rather than direct ones. And that's exactly what this felt like. Now Colleen says she is no longer embarrassed to recommend it End With Us. According to her, she has learned to separate the legal battles from the film itself and from the impact the story has had on readers and viewers. She says that if she can acknowledge that impact and celebrate it, then it's okay for her to feel proud of the film again. But even while saying all of that, she still refused to mention Blake's name. She still refused to mention Justin's name. Instead, she referred to them only as the actors and the director, saying that everyone involved did a great job. Which is interesting, because she didn't do that with her other projects. When discussing those, she had no problem naming the directors and collaborators directly as, oh, now we're seeing a complete reversal. Suddenly the book is recommendable again. Suddenly the film is something she's proud of. And suddenly the embarrassment she talked about months ago seems to have disappeared. But the timing makes it feel less like a genuine change of heart and more like a strategic adjustment. After all, It Ends With Us remains her biggest bestseller. Walking away from it entirely would be difficult when it continues to generate so much money and attention so now the narrative is shifting. Instead of distancing herself from the book, she's focusing on celebrating the success of the film and praising the people involved without ever naming them. And honestly, that's what makes this entire situation feel even stranger, because if she truly believed everyone did such a great job, you would think saying their names wouldn't be a problem. Yet throughout the interview, she carefully avoided it. And beyond all of that, something else came up during the conversation as well. Not only did she attempt to distance herself from Blake and Justin, as if they don't exist, she also hinted at something involving one of her upcoming adaptations that could raise even more questions moving forward. Another thing that came up during this interview involved her upcoming projects. Specifically, the next book she hopes to adapt into films. To understand why this matters, you have to look back at how everything originally unfolded. When book talk exploded and Colleen Hoover suddenly went viral in 2022, her books experienced an enormous surge in popularity. At that moment, Hollywood studios rushed and almost immediately tried to acquire the film rights to her stories. Because of that sudden demand, she ended up selling the rights to several of her biggest titles. The rights to It Ends With Us were sold, along with reminders of him, Verity, and Regretting You. At the same time, she launched her own production company, Hardbone Productions, which allowed her to be more directly involved in some film development. From what she said publicly, it seems like she had the most involvement with reminders of him. She actually wrote the script for that adaptation herself. However, early feedback suggests that the screenplay has not been particularly well received by critics. As for Verity, it sounds like she wasn't nearly as involved in that project compared to the others. During the interview, she was asked what might come next, after having multiple film adaptations announced in such a short period of time. People naturally expected that more projects would already be in development. After all, for separate films tied to one author being released so quickly is not typical in Hollywood. But surprisingly, her answer was basically nothing. She said that none of her other books are currently being developed for film adaptation. According to her, once Verity is released, that will be the final movie based on her work for the foreseeable future. She even said she hasn't seriously thought about what project would come next. She did mention that if another adaptation eventually happens, she would personally like to see either Layla or Heartbones turned into a film. However, she also made it clear that neither of those books currently has a studio attached, and neither project has an official development deal in place. And honestly, that feels a little strange. But when you consider everything that has happened with her previous films, maybe it shouldn't be that surprising. One of the unusual things about Colleen Hoover's film adaptations is the number of different studios involved. Each of her movies has been handled by a completely separate company. It Ends With Us was produced by Sony. Regretting You was handled by Paramount. Reminders of Him is tied to Universal. And Verity is being made by Amazon MGM Studios. When you have that many studios working on projects tied to the same author, it can create a problem. Each studio has its own creative approach, its own marketing strategy, its own executives, and its own production style. That means each film can end up feeling very different from the others. Instead of building a consistent cinematic identity around the author's work, the brand becomes fragmented as a viewer. You might watch one adaptation produced by Sony and then see another produced by Paramount, and the tone, style, and presentation could feel completely different. That kind of inconsistency makes it harder to establish a recognizable brand for films themselves. And it's actually pretty uncommon for authors to have their film adaptation spread across so many studios. For example, Nicholas Sparks worked primarily with Lionsgate and Warner Brothers for most of his romantic drama adaptations. Films like The Notebook, Dear John, A Walk to Remember, and The Lucky One largely stayed within the same studio ecosystem. Because of that, audiences began to associate a specific style and tone with Nicholas Sparks adaptations. That consistency helped build a recognizable brand. The same pattern exists with other authors as well. J.K. Rowling worked almost exclusively with Warner Brothers for the Harry Potter films. Suzanne Collins partnered with Lionsgate for The Hunger Games. And Veronica Roth also saw her Divergent series produced through Lionsgate. Many authors even signed what are known as first-look deals with studios. That type of arrangement allows one studio to have priority access to adapting their future books. But Colleen Hoover doesn't appear to have anything like that. She has also said recently that she no longer plans to sell the rights to her books as easily as she did before. And while that decision may be part of the reason we're not seeing new film deals announced, it probably isn't the only explanation. Because if studios were still extremely confident in the commercial potential of her adaptations, they would likely still be lining up to secure the rights. The financial performance of her first two films might explain why that enthusiasm has cooled. It Ends With Us was released in 2024 with a production budget of around $30 million. Worldwide, the movie ended up grossing roughly $350 million, which was a huge success relative to its budget. But when Regretting You came out in the spring of 2025, the results were very different. That film also had a production budget of about $30 million, yet its worldwide box office only reached around $90 million. That represents a massive drop. In fact, the second film earned roughly $259 million, less than the first one. That's a decline of about 74% between the two releases. And in Hollywood, a drop that large can send a very strong signal to studios. When a second project underperforms that dramatically compared to the first, executives often start wondering if the original success was simply an anomaly. They might begin questioning whether the first film's performance was driven by unique circumstances rather than consistent audience demand. Studios may also start asking whether every book by that author can actually translate successfully to film. Just because one story works doesn't necessarily mean the entire catalog will. So when Colleen Hoover's second adaptation came out and earned only $90 million compared to the $350 million generated by It Ends With Us, it likely made studios far more cautious about investing in additional adaptations. When discussing the success of book-to-film adaptations, it's important to compare how different authors perform when their work reaches the big screen. Some authors benefit from having a series of books that build momentum with each new installment, while others rely entirely on standalone stories that must succeed on their own. A perfect example of the power of a series can be seen with Stephenie Meyer's Twilight franchise. The first film, Twilight, was released in 2008 and earned around $393 million worldwide. Just 1 year later, the sequel New Moon hit theaters and brought in an impressive $709 million globally. That's nearly an 80% increase from the first movie. This type of growth is common in franchises because the audience grows as fans become more invested in the characters and the story. The same trend occurred with Suzanne Collins' The Hunger Games series. The first movie, released in 2012, earned approximately $694 million worldwide. The sequel, Catching Fire, came out in 2013 and performed even better, earning about $865 million, representing roughly a 25% increase in box office revenue. These kinds of numbers demonstrate how powerful a well-established franchise can be when it comes to film adaptations. However, not every author writes in a series format. Some authors specialize in standalone novels, meaning each story exists independently and does not rely on a continuing narrative. One of the most famous examples of this is Nicholas Sparks, whose romance novels have been adapted into several successful films. Sparks' first adaptation was A Walk to Remember in 2002. The movie had a modest $11 million budget, but managed to earn around $47 million at the box office, making it a solid financial success. 2 years later, The Notebook was released in 2004. With a $29 million budget, the film grossed approximately $115 million worldwide, becoming one of the most beloved romantic dramas of its time. In 2008, Knights and Rodanthe arrived in theaters with a $30 million budget and earned about $41 million. While it didn't perform as strongly as The Notebook, it still maintained profitability. Sparks then rebounded with Dear John in 2010, which had a $25 million budget and generated roughly $114 million at the box office. His most recent adaptation during that era, Safe Haven in 2013, had a $28 million budget and earned about $97 million worldwide. What's notable about Nicholas Sparks' film adaptations is their consistency. Even when one film underperformed slightly, there was never a dramatic collapse in box office numbers. Most of his movies were also produced by Lionsgate, which helped maintain a stable relationship between the author and the studio. Because of this reliability, Sparks developed a reputation in Hollywood as a safe investment. His stories had a built-in audience and usually delivered steady financial returns. When we compare this to Colleen Hoover, the situation becomes more complicated. Hoover is undeniably one of the most popular authors to emerge in the book talk phenomenon, and her novels have sold millions of copies worldwide. However, much of her overall success is heavily concentrated in one particular book. It Ends With Us. That novel became an enormous cultural phenomenon, especially after going viral on TikTok. The book sold tens of millions of copies and generated massive buzz online. Because of that momentum, studios quickly moved to acquire the film rights to several of Hoover's novels. But while many of her books have sold well, none have matched the extraordinary success of It Ends With Us. In fact, a large portion of her total sales can be attributed to that single title. Other novels in her catalog have sold millions of copies, but they have not reached the same level of cultural dominance or commercial impact. This difference matters when studios evaluate whether a story will succeed as a film. Early projections suggested that Hoover adaptations could perform extremely well at the box office. However, the drop from projected $350 million performance to closer to $90 million for some adaptations has raised concerns among studios. That kind of decline signals that not every Hoover novel translates effectively to the big screen. Critics are regretting you, for example, argue that the story felt overly melodramatic and resembled something more suited to a Lifetime television movie rather than a theatrical release. Reviewers also pointed out issues with the acting, the dialogue, and the pacing, suggesting that the film felt somewhat disjointed. Similar concerns have been raised about reminders of him. Some critics believe the storyline is unusual and difficult to translate into a compelling film narrative. Others argue that the characters can be hard for audiences to connect with or root for emotionally, which can weaken a romantic drama's impact. The release strategy for reminders of him also reveals how cautious studios have become. The film was originally scheduled to premiere in February, but the studio decided to delay it until March 13th. The main reason for this decision was to avoid direct competition with another major romantic drama, Wuthering Heights, which was also scheduled for release in February. Wuthering Heights quickly proved to be a massive success, already earning over $200 million worldwide. Facing such strong competition in the same genre, the studio behind Reminders of him chose to stagger the release date in hopes of finding a less crowded window at the box office. The mid-March timing also coincides with spring break, when more people tend to go to movies. However, even with the delayed release, Wuthering Heights remains in theaters, meaning there is still competition for audiences interested in romantic dramas. This further complicates the performance outlook for Hoover's adaptation. Another factor affecting Hoover's dominance is the rapidly changing nature of book talk culture. Social media trends move quickly, and new authors constantly emerge. Recently, books like The Housemaid have gained attention, and authors such as Ollie Hazelwood are beginning to see their own works adapted into films. Because of this shifting landscape, Hoover's books are no longer the singular focus of the online reading community. Studios often try to capitalize on viral popularity while it's at its peak, but timing is critical. If too much time passes, the cultural momentum can fade. That may also explain why another Hoover adaptation, Verity, has faced delays. Although filming reportedly wraps sometime in late 2024 or early 2025, the movie still hasn't received a firm release date. Studios may be reconsidering how and when to release these projects based on performance of earlier adaptations and the evolving landscape of book-to-film trends. In the end, the success of Colleen Hoover adaptations will likely depend on whether Hollywood can identify which of her stories truly resonate with audiences on screen and which ones might be better left on the page. Another interesting factor affecting the future of Colleen Hoover's film adaptations is the timing of upcoming releases and the actors attached to these projects. One example that highlights this issue is the upcoming adaptation of Verity, which has reportedly faced delays in its release schedule. Initially, there was speculation that the film might arrive earlier, but it now appears that it won't be released until fall. One of the reasons for this delay is connected to the busy schedule of Anne Hathaway, who is attached to the project. Hathaway is already set to appear in several major films during 2026, including the highly anticipated sequel to The Devil Wears Prada. The follow-up, The Devil Wears Prada 2, is expected to release in the spring of 2026, and studios reportedly didn't want Verity to compete directly with such a major and widely anticipated film. But the scheduling issue goes beyond just avoiding direct competition with one movie. Hathaway is expected to appear in multiple films between the spring and fall of 2026, which means that by the time Verity finally reaches theaters, it could potentially be the fourth film featuring Anne Hathaway release within roughly 6 months. From a marketing standpoint, that kind of visibility can be both a blessing and a risk. When an actor appears in too many films within a short period, audiences sometimes experience what the industry calls actor fatigue. In other words, viewers may feel oversaturated by seeing the same performer repeatedly in similar genres. This can especially happen in romantic dramas, where the emotional tone and storytelling style can begin to feel repetitive if the same star appears across multiple projects. Because of this, studios may worry not only about whether audiences will show up for a Colleen Hoover adaptation, but also whether moviegoers might feel fatigued by seeing Anne Hathaway headline several romantic or dramatic films in such a short time frame. Hollywood history has shown that even very popular actors can experience periods where the market simply becomes oversaturated with their work. Another point that raises questions about Hoover's current position in Hollywood is the apparent lack of additional projects based on her books currently moving through production. Despite her massive popularity as an author and the viral success of her novels on social media platforms like BookTok, there are very few confirmed film projects actively being developed from her catalog at the moment. That absence becomes even more noticeable when considering reports that Hoover was interested in acquiring the rights to a novel by Ollie Hazelwood in mid-2025. Hazelwood is another author who gained significant popularity online, particularly with romance readers. If Hoover already had a strong pipeline of her own stories being adapted, it might seem unusual for her to pursue someone else's work so aggressively. This raises an interesting question. Why would Hoover seek out another author's book when she has an entire library of her own novels available for adaptation? Books such as Heartbones and Layla already exist and have their own fan bases. If studios were eager to continue producing Hoover adaptations, it would make sense for those titles to be natural candidates for future projects. One possible explanation is that studios may have cooled somewhat on adapting additional Hoover novels, particularly if recent projects have not performed as strongly as expected. In Hollywood, success often leads to rapid expansion, but any noticeable decline in performance can cause studios to become cautious very quickly. Another factor to consider is Hoover's attempt to establish herself not only as an author, but also as a producer and film creator. Launching a production company can be an exciting step for any writer who wants more creative control over how their stories are adapted. However, the film industry operates very differently from the publishing world. Producing films requires enormous amounts of capital, financial backing, and risk tolerance. Even relatively modest productions can cost tens of millions of dollars, and there is never a guarantee that a movie will recover its investment at the box office. Because of this, most films rely on large studios or extremely wealthy investors who are willing to take those risks. Without significant financial backing, a production company can struggle to compete with major studios. Independent production companies often have to operate on much smaller budgets, which limits the scale of the films they can create. Large-scale theatrical releases usually require substantial funding for not only production, but also marketing and distribution. For example, major investors like Steve Sarowitz have previously supported large creative ventures by providing the financial resources necessary to develop ambitious projects.
But another person who is deeply connected to this reached out and said, because you're almost there, you're only missing one detail, and I'm starting to wonder and remember pure speculation with no proof what made him react that wildly did something happen between Justin Baldoni and Blake Lively.
So talk to me about how sometimes you were even the intimacy coordinator in some of the scenes, like we saw you.
That shouldn't be happening, by the way. I just want to be clear that you should not be the intimacy coordinator. You should definitely hire intimidators, which we did have, thank
You were
goodness.
teaching Justin how to pull you in.
Where have
I
you
loved
seen
that.
I actually just saw it too. It was on Instagram yesterday, I think. Yeah.
I think that, like, you know, romance is really important. You're supposed to, you know, tell a story.
Well, it's been a minute since we talked about the ongoing legal battles involving Justin Baldoni and Blake Lively, and today there's some major news to share. Yesterday, Wayfarer Studios and It Ends With Us Movie LLC, along with several individual defendants, including Jennifer Abel, Melissa Nathan, and others, received a major legal victory. Judge Lyman issued a detailed ruling that effectively gutted Blake Lively's lawsuit, leaving almost nothing standing. For context, this case has been in the public eye for months. Lively initially brought numerous claims alleging sexual harassment, retaliation, and other workplace misconduct during production of It Ends With Us. The case attracted attention not only because of the parties involved, including Justin Baldoni, a well-known actor and director, but also because of the broader implications for employment law in the film industry. The judge's ruling makes clear that most of Lively's claims were dismissed. Only a very narrow subset of claims remains. A contract dispute related to the 17-point CRA agreement, and a couple of retaliation claims under FEHA, California's Fair Employment and Housing Act, that might still be subject to dismissal. Essentially, the vast majority of the original claims, including sexual harassment allegations and individual liability claims against Baldoni, Heath, and others, have been eliminated. This is a highly significant win for the defendants. The judge's order was not only scathing in his critique of the legal basis for Lively's claims, but also impressively detailed. He focused extensively on the fact that Lively was not a traditional employee under employment law. Sexual harassment claims require the existence of an employment relationship where there is a power imbalance, typically defined by control, who has authority over hiring, firing, and daily work activities, in this case. The court found that Lively exercised as much, if not more, control over production than anyone else. The ruling highlighted that she had negotiated extensive contractual rights, including approval over key aspects of the film, the ability to take on other projects during production, and the option to walk away at any point with only a potential breach of contract as a consequence. Because of this level of control, she was not eligible to bring claims under Title VII, which protects employees from harassment by employers or supervisors. The judge also examined Lively's role in depth. He emphasized that she was far more than just an actor following directions. She had influence over hiring and firing assistants, negotiated to relocate filming closer to her home, rewrote portions of the script, and regularly held meetings with department heads and the studio. She oversaw a team of editors, shaped the creative direction of the film, and contributed to marketing strategies and release planning. Her compensation included equity in the film, tying her earnings to the success of the project as a whole, rather than solely to her individual performance. These factors collectively established that she held significant economic and creative independence, a SA result. The court concluded that she could not claim the sort of powerlessness that is required to pursue sexual harassment claims. The ruling essentially confirmed that much of her lawsuit, which heavily relied on the premise that she was a subordinate employee, lacked legal merit. Despite this, the judge had allowed 2 retaliation claims to proceed. These claims focus on Lively's allegations that she was retaliated against for speaking up about concerns on set, specifically efforts that allegedly damaged her reputation through digital campaigns and public relations activities. However, even these claims are heavily narrowed and will ultimately depend on what a jury finds credible. The court repeatedly emphasized that credibility and factual disputes are central to determining whether retaliation occurred, but this does not guarantee a verdict in her favor. Representatives of the defendants issued statements praising the ruling. Brian Friedman, representing Wayfarer and the film company, emphasized that the defendants have consistently defended themselves transparently, providing documents and text messages to show the truth. He reiterated that neither Baldoni nor any other defendant engaged in sexual harassment, and that the court's decision validates their defense. Alexander Shapiro and Jonathan Bach echoed this sentiment, noting that all harassment claims and claims against individual defendants were dismissed, and expressing gratitude for court's careful review. They also highlighted that the case case is now significantly narrowed, allowing them to focus on defending the limited claims that remained at Lively's team. In turn, maintained that the case is always centered on retaliation and efforts to harm her reputation after raising safety concerns on set. They stated that she looks forward to testifying on those matters and presenting her perspective to a jury. While this claim remains, it is important to note how limited it is compared to the original breadth of allegations, which initially included sexual harassment, conspiracy, and defamation. The ruling also serves as a reminder of the importance of contractual control in high-profile projects. Lively's own statements, including her PGA letter, were used extensively by the judge to establish her influence and authority over production. By negotiating rights over creative decisions, scheduling, and script approval, she was found to have a level of control that placed her outside the protections afforded to typical employees, in short. This ruling represents a decisive win for defendants and a significant narrowing of Lively's legal claims. While the retaliation claims still exist, the majority of her lawsuit has been dismissed, and individual defendants are no longer personally at risk. As the case moves forward, it will largely hinge on whether a jury finds enough credibility and factual basis for the limited claims that remain. This is a remarkable development in a high-profile case, and it underscores how legal strategy, contractual arrangements, and careful documentation can dramatically influence the outcome of complex employment and entertainment law disputes. For Wayfarer, it ends with Us Movie LLC and their teams. This ruling is not just a procedural victory. It's a strong affirmation of their legal position and an important precedent for similar cases in the entertainment industry. All of this underscores a central point. The judge did not accept the argument that Blake Lively was under the direct control of Wayfarer Studios, or that her paycheck dictated her role in production, nor did he find that she was bound to follow Justin Baldoni's directions as if he were her supervisor. On the contrary, the court highlighted that Baldoni often had consult with Lively before making changes to the script, altering scenes, or implementing creative decisions. This level of autonomy was critical in the judge's determination that Lively was not an employee under either FEHA, California's Fair Employment and Housing Act, or Title VII federal LAW, by classifying her as an independent contractor. The judge took a strategic path that allowed him to largely sidestep the thorny question of whether the alleged incidents on set legally constituted sexual harassment. While the ruling does touch on these events later in the context of retaliation, the focus is narrowly on whether Lively herself believed the conduct occurred, rather than whether it objectively met the legal threshold for harassment. Under employment law, this distinction is important. For retaliation claims, a plaintiff's subjective belief can be sufficient to move forward, even if the conduct itself does not satisfy the strict legal definition of harassment. In this case, the judge carefully avoided making a determination on the objective legal standard, leaving the door open only for a narrow set of claims. The ruling makes clear that Lively's sexual harassment claims under both FEHA and Title VII were dismissed primarily because she was classified as an independent contractor. This classification significantly impacts the applicability of these laws because employment protections under FEHA and Title VII are designed to shield employees who are under control of an employer, not independent artists exercising contractual autonomy. In addition, the judge noted that the alleged conduct was not sufficiently tied to California to invoke extraterritorial application of FEHA, further limiting her ability to pursue claims under that statute. Despite these dismissals, a narrow category of FEHA-related claims survived, specifically those tied to alleged retaliation. These claims hinge on the argument that Lively experienced negative consequences after raising concerns about on-set conduct. Importantly, retaliation claims do not require that the underlying behavior legally constitute harassment. They only require that the plaintiff reasonably believed they were opposing improper practices. In other words, the law protects individuals from retaliation even when the initial conduct may not meet the legal standard for harassment, provided the employee or contractor genuinely perceived it as objectionable and complained to appropriate channels. The judge also addressed claims of aiding and abetting related to retaliation, denying them without prejudice. This means that while the claims were not sustained at this stage, the plaintiffs could potentially reassert them later, depending on how the evidence develops. This procedural nuance underscores the complex interplay between individual responsibility and organizational liability in employment law cases. Many of Lively's remaining claims were considered plausible in the sense that they involve factual disputes rather than proven misconduct. In legal terms, a plausible claim is one where the facts are contested. One side claims an event occurred, and the other side denies it. These types of disputes are typically resolved by a jury, not a judge, which is why retaliation and harassment-related claims are often challenging to dismiss outright. The judge noted that the same principle applies to issues surrounding the alleged digital campaign against Lively, which involve competing narratives and factual disagreements that a jury could evaluate if the case moves forward. Contractual matters also played a significant role in the ruling. California-based claims tied to the so-called ALA agreement were dismissed in part because the court found the agreement was not signed or otherwise enforceable. The only contract the court found enforceable was a 17-point CRA agreement, which included explicit provisions relating to retaliation. This is why one contract-related retaliation claim continues to move forward, while all other claims tied to the ALA agreement were eliminated. Finally, the judge emphasized a key point regarding protected activity. While some alleged incidents may not legally rise to the level of sexual harassment, they could still qualify as protected activity if Lively reasonably believed them to be harassment. In such a scenario, the law protects her from retaliatory actions that occur as a result of raising complaints or opposing conduct she subjectively perceived as wrongful. The judge noted that a reasonable jury could conclude that Lively opposed practices she believed to be harassment by submitting formal complaints, engaging in meetings, and raising concerns in other professional communications. Because the defendants did not robustly challenge her subjective belief at this stage, these limited claims were allowed to survive. In short, this ruling demonstrates the complex nature of employment law, particularly in the entertainment industry, where independent contractors often maintain substantial creative and contractual control. It also highlights the distinction between objective legal standards for harassment and the subjective beliefs that can sustain retaliation claims. While most of Lively's claims were dismissed, the surviving retaliation and contract-related claims reflect the careful balance courts maintain between protecting individuals from retaliation and ensuring that legal claims are grounded in demonstrable employment relationships. The case now moves forward in a highly narrowed form, focused primarily on the specific and contested aspects AT trial. Both parties will have the opportunity to present evidence to either support or challenge whether Blake Lively genuinely believed she experienced retaliation or harassment. The judge made clear that while her subjective belief can sustain a claim for limited purposes, it does not automatically prove that the conduct was unlawful. Essentially, the court distinguished between what Lively perceived and what could be legally classified as harassment under employment law, emphasizing that the focus at this stage is on her perception rather than an objective legal determination. When examining specific allegations, the judge provided careful context to evaluate whether the incidents could contribute to a hostile work environment. One example involved a conversation about circumcision. While Lively found the discussion uncomfortable, the judge noted that it occurred within the context of a broader conversation about medical decisions, potentially even a topic she introduced herself. Crucially, the incident took place before she began principal photography on the film, meaning it could not have created or contributed to a hostile work environment under legal standards. This distinction is significant because employment law typically considers the timing and context of alleged incidents when evaluating their impact on the work environment. The judge further emphasized that alleged conduct, when viewed in isolation, often does not rise to the level of a hostile work environment. Context is key in determining whether behavior is legally actionable. For instance, during pre-production, there were discussions about proposed edits to the screenplay, including scenes involving intimacy that Lively personally found unnecessary or gratuitous. The judge concluded, however, that suggesting intimate scenes in the development of film with adult themes does not constitute an objectively hostile or objectionable environment. In the entertainment industry, it is standard for directors, writers, and producers to explore material that may include sexual or sensitive content, and this creative exploration alone does not equate to discrimination. From a broader creative standpoint, the court noted that it is neither surprising nor unreasonable for collaborators, such as Baldoni and Lively, to draft and debate explicit material, even if one party disagrees with the other's vision. Artistic disagreements are a normal and expected part of filmmaking. Communication submitted as evidence even indicated that the studio encouraged pushing the boundaries of tasteful but intense intimacy to elevate the film's storytelling. This reinforces the idea that creative decisions, however personally uncomfortable they might be, are distinct from conduct that constitutes harassment under the law. The court also referenced established precedent, noting that actors performing sensitive or sexually suggestive dialogue would reasonably understand that such dialogue is part of performance and creative process. It is not an expression of hostility or animus based on gender. While an actor might subjectively experience discomfort, the law recognizes that personal unease does not, on its own, establish a legally actionable hostile work environment. The principle extends beyond performance to screenplay development. Disagreements about gratuitous or explicit scenes are considered creative differences rather than evidence of gender-based discrimination. The record demonstrated that both Lively and Baldoni proposed scenes the other found objectionable, highlighting that the conflict was collaborative and artistic rather than discriminatory. Allegations of fat shaming were similarly scrutinized. Lively had raised concerns about comments regarding her weight, particularly as she prepared for physically demanding roles. The judge found that these allegations, while personally distressing, did not reasonably support a claim of discrimination based on gender. The court emphasized that Lively had significant control over her preparation and participation in the project, including the ability to negotiate filming schedules, approve creative choices, and maintain autonomy over her performance. Her efforts to manage her physical appearance were part of standard professional expectations for a role, not evidence of gender-based discrimination. Additionally, the court considered how any alleged discomfort must be evaluated within the overall production environment. Filmmaking involves collaboration among actors, directors, producers, and other creative professionals. Scenes are often rehearsed, revised, and discussed extensively, sometimes including content that may be sensitive or challenging. The judge highlighted that while certain moments may have caused personal discomfort, such experiences are inherent to the professional context and do not constitute harassment without additional evidence of discriminatory intent or conduct aimed specifically at a protected class. Finally, the ruling reinforced that the legal threshold for a hostile work environment is high. It requires conduct that is objectively severe or pervasive enough to create a work environment that a reasonable person would find intimidating, hostile, or abusive. Discomfort or disagreement over creative choices, isolated comments, or subjective unease does not meet the standard. In sum, the judge found that while Lively may have experienced personal discomfort or disagreement during the creative process, the evidence did not support the legal conclusion that these interactions constitute harassment based on sex or gender. Shortly before filming began, Blake Lively had recently given birth and expressed a clear desire to be in peak physical condition for her role. Preparing for a physically demanding part was important to her, both in terms of performance and for the marketing and overall success of the film. During pre-production, there were instances that Lively later described as making her uncomfortable. For example, Justin Baldoni asked the trainer about her potential weight at the start of filming. Additionally, she was introduced to a probiotic specialist, who Lively later discovered focused primarily on weight loss. These actions, while perhaps well-intentioned, contributed to her perception of being scrutinized regarding her physical presentation. While weight-related comments and attention to physical appearance can, in certain workplace contexts, contribute to a hostile work environment claim, the court found that there was no evidence these actions were directed at Lively because of her gender, nor was there any indication that Baldoni harbored hostility toward women in general. Instead, the discussions were contextualized as part of preparing for a specific film role that required particular physical aesthetic. Lively herself had acknowledged that achieving a certain look was integral to her role and had taken proactive steps to ensure she was ready, including requesting the scheduling of scenes to allow adequate training time and consulting her agent regarding her fitness regimen. In essence, the judge concluded that the alleged conduct was tied to professional expectations of the role rather than any discriminatory intent. The court emphasized that the ultimate inclusion or exclusion of specific scenes in the film was irrelevant to a harassment analysis. Editing decisions, script revisions, and adjustments during filming are all part of the normal creative process in filmmaking. The judge observed that disagreements over scenes, including those Lively personally found uncomfortable, reflected creative differences rather than gender-based discrimination. For instance, one scene involving a lift, which Lively later linked to her concerns about weight, was ultimately cut. The mere discussion or removal of such a scene does not constitute harassment or discrimination under the law, and a more prominent focus was the dance scene cited by Lively. The script instructed that the characters dance closely, but did not detail every physical interaction. Lively alleged that Baldoni improvised additional gestures, including leaning in, touching her face, and making intimate gestures. The court reviewed video evidence of the scene, noting that it was filmed in front of a large crew, that both actors were actively improvised within the framework of the scene, and that multiple background actors were present. The judge observed that in another context, such as a traditional office environment, such actions might support a claim of hostile work environment. However, in the context of a film set, the critical question is whether Baldoni's conduct could reasonably be interpreted as targeting Lively as a woman rather than her character. Under this lens, the judge concluded that it was difficult to interpret the behavior as reflecting hostility or gender bias. The conduct was part of performing a scripted scene, and, even if improvised, fell within the bounds of what could reasonably be expected between two characters during a slow dancing sequence. The court underscored a broader principle applicable to creative industries. Actors, directors, writers, and other artists require space to experiment and explore performances within the bounds of script without being automatically subject to harassment claims. Improvisation, scene adjustments, and dynamic interaction between actors are hallmarks of the creative process. When viewed in this light, the judge determined that the dance scene and other similar interactions did not meet the legal threshold for sexual harassment or a hostile work environment in this specific context. However, the judge also recognized that certain behaviors could approach the line of creating a hostile work environment if they involved commentary on personal experiences or subjective matters unrelated to the role. Lively testified about remarks concerning her wardrobe and the sexualized nature of costume choices. She claimed that Baldoni made comments regarding actors' bodies and attire, which she described as ranging from unnecessary to inappropriate and distracting. These allegations prompted the judge to carefully consider the context and scope of such commentary. Crucially, the court noted that Lively herself had described her wardrobe as sexy, and this self-characterization limited the extent to which such commentary could be interpreted as harassment. The judge emphasized that one's personal description of clothing or appearance does not give license for broader comments that can be construed as targeting a protected class. The court also addressed the broader framework of creative collaboration, emphasizing that actors and directors frequently engage in discussions that involve elements of performance, wardrobe, and physical presentation. Such dialogue is essential to shaping the authenticity and effectiveness of a character and story. While a performer may feel personally uncomfortable at times, the law recognizes that discomfort alone is insufficient to constitute harassment. There must be evidence that the conduct was gender-based, severe, or pervasive in a way that creates an objectively hostile environment. In this case, the judge found that no such evidence existed. Additionally, the court considered the interplay between subjective perception and objective reasonableness. Even if Lively personally felt uncomfortable with certain interactions or commentary, the judge highlighted that harassment claims require a reasonable person standard, whether a typical individual in her position would view the conduct as hostile or discriminatory. Within the highly collaborative, public, and performance-oriented environment of a film set, the actions alleged did not meet this threshold. Improvisation during a scene, commentary on performance-related topics, and discussions about wardrobe and aesthetics are fundamentally different from discriminatory conduct in traditional workplaces. The judge also addressed allegations regarding production's digital and marketing campaign. Lively claimed that online promotions and media narratives targeted her unfairly. The court, however, distinguished between professional marketing strategies and unlawful retaliation, noting that decisions regarding publicity, promotion, and content dissemination are within the purview of the studio and production company. While these actions might have impacted Lively's perception, they do not constitute harassment under the law unless they can be directly tied to discriminatory intent. End conclusion. The judge's ruling reflects a careful, nuanced understanding of the creative process and professional autonomy in filmmaking. While some of Lively's experiences may have been personally challenging, they were largely tied to the demands of the role, collaborative decisions, and standard production practices rather than gender-based discrimination. The court's analysis reinforces that in artistic and performance contexts, conduct must be evaluated through both a subjective lens, what the individual perceives, and an objective lens, what is reasonable within professional and creative setting. Ultimately, the judge found that Baldoni's actions, while potentially uncomfortable or unconventional, did not legally rise to the level of harassment. The court's ruling on Blake Lively's lawsuit reflect a careful balance between reviewing her allegations and applying the legal standards that govern workplace harassment, retaliation, and contract disputes. While the judge acknowledged that a jury could theoretically examine all the evidence, he made clear that the isolated incidents alleged by Lively were unlikely in themselves to constitute a hostile work environment. The key distinction made by the court is between discomfort or awkwardness arising from creative collaboration and conduct that is legally actionable under the law. However, the judge's reasoning allowed certain retaliation claims to move forward, as they involve broader disputes over workplace treatment and perceived attempts to harm Lively's professional reputation. One example highlighted by the court involved Jamie Heath entering Lively's trailer while she was partially undressed. The judge noted that this incident could reasonably be viewed as hostile, particularly because it violated expectations of privacy. Similarly, the so-called birth scene in the film presented unique challenges. In that scene, Lively performed simulated nudity from below the chest down, with her legs uncovered, and testified that she had not anticipated or consented to that level of exposure. The court reviewed the offer letter, which specifically stated that no simulated sex would occur without Lively's prior written consent. Lively claimed she felt compelled to compromise to perform the scene as directed, underscoring the complexity of creative production environments where consent, direction, and performance expectations intersect. The judge also considered industry practices and a role of intimacy coordination, noting that Lively submitted evidence suggesting that a professional intimacy coordinator may have been warranted. While the court did not explicitly agree with this assessment, it acknowledged that the question raised legitimate points of consideration, particularly in terms of how industry standards apply in high-intensity filming situations. Importantly, the court distinguished between partial nudity that was scripted and fully nude exposure, emphasizing that the scenes in question did not involve full nudity, which mitigated the claim that the work environment was systematically hostile. Other interactions cited by Lively, such as conversations about the content of certain scenes or comments made in the context of creative decision-making, were largely dismissed as non-actionable. For instance, the judge examined remarks attributed to Baldoni about Lively never having viewed adult content, and found no evidence that such comments were definitively made. The court clarified that many claims would ultimately depend on credibility and corroborating evidence, including whether witnesses could confirm the allegations. In essence, the judge framed these disputes as factual disagreements that a jury could evaluate, rather than as clear-cut violations of law. Regarding the birth scene and broader production decisions, the court concluded that a reasonable person in Lively's position could have perceived the workplace as, at times, reflecting a gendered and sexualized perspective, coupled with potential disregard for privacy. This perception, the judge explained, was sufficient for Lively to reasonably raise complaint about a hostile work environment. However, the court emphasized that these were alleged incidents, not legally proven facts. The critical legal standard is whether a reasonable person could interpret the behavior as hostile, not whether the conduct actually meets the threshold for harassment under employment law. This distinction allowed the court to permit certain retaliation claims to proceed without ruling definitively on harassment. The court also addressed controversy surrounding the digital campaign and media coverage. Lively claimed that Wayfair and affiliated parties engaged in concerted effort to bury her reputation, including promoting negative content. such as a video portraying her as insensitive to domestic violence survivors, and circulating a Daily Mail article labeling her a mean girl. These actions were flagged as potential instances of retaliation. However, the judge distinguished between standard business practices, including public relations and crisis management, and legally actionable retaliation. Companies are generally entitled to manage their public image and respond to media narratives, provided their actions do not cross the line into unlawful conduct. Only specific instances, such as amplifying targeted videos or negative articles, were considered potentially crossing that line, leaving these points for jury evaluation if the case proceeds. The court highlighted the complexity of establishing retaliation claims, noting that much of the dispute arises from differing interpretations of events and intentions. For example, the record suggested efforts by production teams to shift narratives in traditional media by focusing on Lively's alleged marketing missteps. While these actions could be viewed as defensive or strategic, a jury might interpret them as deliberate attempts to harm her professional reputation. The court's reasoning demonstrates a careful distinction between subjective belief, actual misconduct, and legal standards for workplace claims. In cases where credibility is contested, juries are tasked with evaluating the reliability of witnesses, the plausibility of narratives, and the context in which events occurred. Ultimately, the judge concluded that the retaliation claims could proceed to trial. This decision was not an endorsement of Lively's claims, but rather a recognition that there were enough disputed material facts to warrant jury review. The court made clear that the case's continuation is due to these factual disputes rather than an assessment that the alleged conduct unquestionably constitutes retaliation. In other words, the law recognizes that when credible disagreement exists over core facts, such as whether actions were intended to harm, whether consent was provided, and whether communications were malicious, these issues should be resolved by a jury, not by a judge at summary judgment. A essay resulted in a ruling. All other claims against individual defendants were dismissed. The remaining causes of action are sharply narrowed. Lively's 4 causes of action for retaliation under the California Fair Employment and Housing Act FEHA against It Ends With Us movie and Wayfair, her 7th cause of action against TAG for fear of retaliation and aiding and abetting, and her 9th cause of action for a breach of contract against It Ends With Us movie.
So talk to me about how sometimes you were even the intimacy coordinator in some of the scenes, like we saw you.
That shouldn't be happening, by the way. I just want to be clear that you should not be the intimacy coordinator. You should definitely hire intimidators, which we did have. Thank
You
goodness.
were teaching Justin how to pull you in.
Where have you seen this?
I actually just saw it too. It was on Instagram yesterday, I think.
I think that, like, romance is really important. You're supposed to, tell a story.
You remember when they dismissed Baldoni's claims and he left open a couple contract disputes? That's essentially what's happening here with a contract dispute over the CRA, which is that 17-point agreement, and then a couple FEA claims that theoretically, if they wanted to renew, they might be able to get tossed for retaliation. So this is a pretty scathing order by the judge, and I'm impressed with the detail and how focused he was. And remember how I said that if he made a decision on whether or not she was an independent contractor, he would be able to dispose of the lawsuit without verifying claims of SH? He could bypass having to tell Blake she was not meeting the legal standard and instead say, well, you're just not allowed to bring these claims because you're an independent contractor. That's the exact route he took. And as I suspected very early on, if you remember, I was one of the first people back in the spring of 2025 to bring up the fact that I did not believe she was an employee nor that she was allowed under the law to bring these claims. Because SH claims for employment law require that you be an employee. They require that you have no control because SH in the workplace is about power. It's about a power differential. It's about who has control. And in this case, the judge said Lively had as much, if not more control than anyone else. So essentially, he got rid of every single one of her sexual harassment claims without having to say, you're a liar. He did hold on to 2 of the retaliation claims, and I'll get to that in a second. But this is a huge win for them, and I think the judge was really fair. Before I actually tell you what happened in the court records, I do want to say that I reached out to Wayfarer, and I got 2 statements. Brian Friedman provided a statement which said that since the first day of this case, when Justin and the other defendants were blindsided by these allegations, the legal team worked extremely long days and nights defending the case through transparency, BY releasing actual text messages, and facilitating the release of all documents exhibiting the truth. The defendants were not afraid of the truth. The plan was not only to speak the truth, but to show that same truth repeatedly through the presentation of real evidence. Neither Justin Baldoni, Jamie Heath, nor any of the other defendants engaged in any sexual harassment of Blake Lively. Despite their clients being accused of Darvo and referred to in writing as a predator, what was said from day one remains true. The clients are good people who did not engage in the alleged behavior. As such, they deserved a strong defense led through transparency. It is gratifying to see the court's ruling confirm what the legal team believed from the beginning. I also received a separate statement from Alexander Shapiro and Jonathan Bach. They said they are very pleased the court dismissed all harassment claims and every claim brought against the individual defendants, including Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and Jennifer Abel. These were very serious allegations, and they are grateful to court for its careful review of the facts, law, and extensive evidence that was provided. What remains is a significantly narrow case, and they look forward to presenting their defense to the remaining claims in court. Now, in fairness, Blake Lively's team has also released a statement saying the case has always been and will remain focused on the retaliation and the steps the defendants allegedly took to damage her reputation because she stood up for safety on set. They say that is the case going to trial. For Blake Lively, the measure of justice is that the people behind the alleged coordinated digital attacks have been exposed and are being held accountable. She looks forward to testifying and continuing to highlight retaliation so it becomes easier to identify and challenge. After all of that, this order is extremely long, and it wouldn't make sense to read every part of it. But I do want to point out that Lively's own letter really worked against her because the judge used it to determine how much control she had. That ultimately became the basis for why she wasn't covered under Title VII or eligible to bring sexual harassment claims. Instead of reading the entire order, one key part explains it clearly. The judge stated that Lively is a highly skilled artist who agreed to contribute her acting skills and name recognition to a single-purpose project for a limited term. She had heavily negotiated approval rights over her performance and key aspect of the project, along with the ability to accept other work outside of the short 6-week window when she was required on set. Not only did she reserve substantial contractual control over her participation in the film, but she also actively exercised that control. The court did not need to rely solely on her statement in the PGA letter that she produced every moment of the film to determine that her role far exceeded that of a traditional employee. She played a role in hiring and firing assistants, negotiated for filming to be relocated closer to her home, rewrote parts of the script, and conducted meetings with department heads and the studio. She oversaw a team of editors and played a central role in shaping the film's look, marketing, and release strategy. She also had the economic independence to walk away at any time, with the only consequence being a potential breach of contract. She exercised that independence when negotiating the terms under which she would return to work. In addition, she held equity in the film, meaning her compensation was tied not only to her own performance, but also to the overall success of the project. All of this strongly indicates that the judge did not accept the argument that she was under control of Wayfarer simply because they issued her paycheck or that she was bound to be directed by Baldoni. In fact, the judge stated that Baldoni had consulted with her if he wanted to make changes to the script, adjust scenes, or implement creative decisions. Based on this, she was not considered an employee. This was a strategic decision by the judge because it allowed him to avoid ruling on whether the alleged conduct on set met the legal standard for sexual harassment. While he does address the allegations later in the context of retaliation, he focuses only on whether she believed the conduct occurred, not whether it actually met the legal threshold. Under the law, a subjective belief can be sufficient at this stage, even if it does not ultimately meet the required legal standard. The judge did not conclude that the alleged behavior met that standard and avoided making a definitive determination on several claims, dismissing many of them outright. He dismissed her claims under FEA and Title VII on the basis that she was an independent contractor. Additionally, the FEA claims were dismissed because the alleged conduct was not sufficiently tied to California, meaning the law did not apply extraterritorially. The only reason some retaliation-related claims survived was that she presented arguments that could potentially connect them to California. The judge also noted that the defense could revisit certain arguments, as the aiding and abetting claim related to harassment was denied without prejudice, leaving room for it to be challenged again. Before discussing how the judge dismantled some of the more extreme allegations, it's important to note that while some claims were dismissed, others were considered plausible in the sense that they are disputable and therefore suitable for trial. This does not mean they are true, only that they involve factual disagreements that must be resolved by a jury. This is why harassment and retaliation claims are often difficult to dismiss early, as they frequently depend on conflicting accounts of events. Many of the issues surrounding the alleged digital campaign fall into this category and are considered matters of fact for a jury, rather than legal questions for a judge. The judge also ruled that certain California-related claims could not proceed because the ALA was not signed or enforceable. The only contract deemed enforceable was a 17-point agreement, which included provisions related to retaliation. As a result, one contract-based retaliation claim will move forward, while others were dismissed due to the lack of enforceability of the ALA. This aligns with what was anticipated during oral arguments. The dismissal of the California employment law claims also meant that the sexual harassment allegations tied to those claims were no longer viable. Regarding the timeline of events, the judge noted there was no real dispute about when the alleged protected activities occurred, specifically referencing incidents in early 2024 and later in the year. He stated that even if those actions did not rise to the level of sexual harassment under the law, they could still qualify as protected activity. He further noted that a reasonable jury could find that she believed she was opposing inappropriate conduct based on her complaints. The defense did not strongly contest her subjective belief, and there was enough evidence to suggest that she genuinely felt she had been subjected to improper treatment. This emphasis on subjective belief was a key strategy, as such issues typically must be resolved by a jury. If the case proceeds to trial, both sides will present evidence to support or challenge whether that belief was reasonable or genuine. At this stage, the judge is simply stating that he cannot make that determination himself. When addressing specific allegations, the judge examined an incident involving a personal medical discussion that made her uncomfortable. However, he noted that the conversation occurred in a broader context about medical decisions and may have even been initiated by her. More importantly, the interaction took place before filming began, meaning it could not contribute to a hostile work environment. Other isolated incidents were also found insufficient to establish such a claim. For example, discussions about intimate scenes and script edits were considered part of the normal creative process in developing a film with mature themes. The judge concluded that proposing or discussing such material, even if one party found it distasteful, did not create an unlawful or hostile environment. From a creative standpoint, it was not unreasonable for both parties to contribute ideas involving explicit content, even if they disagreed on its appropriateness. Evidence also showed that studio input encouraged pushing boundaries in a controlled and tasteful manner, further supporting the context in which these discussions occurred. Dialogue and performance would reasonably be understood as part of the role, part of the surrounding circumstances, expectations, and relationships tied to production rather than an expression of hostility or animus toward a particular gender. An individual actor might find certain performances subjectively uncomfortable or even painful, but without more, that alone would not establish a hostile work environment claim. Even if the dialogue involves sexual content, it is not automatically discriminatory or hostile toward an employee based on sex. The judge explains that the same principle applies to screenplay. Discussions about adding scenes, even those considered gratuitous, are part of the creative process. Arguments made publicly about such scenes being inappropriate were dismissed as irrelevant because both parties were collaborating on a film project, and either side could contribute material that the other found objectionable. The fact that evidence showed both sides proposing scenes reinforced the idea that this was not about gender-based hostility, but rather creative differences. The judge also addressed claims of weight-related comments and found they did not reasonably support a harassment claim. Shortly before filming began after giving birth, she expressed a desire to be in peak physical condition for the role. Around that time, Baldoni asked a trainer, who was also working with her, about her expected weight at the start of filming. This information was relayed back to her, and she found it unsettling that on another occasion, she was introduced to a specialist in probiotics, who she later learned focused on weight loss. While comments about weight directed at only one gender could, in some cases, support a hostile work environment claim, the record here did not show that the conduct was targeted based on gender. The judge concluded that these actions could not reasonably be interpreted as hostility toward her as a woman or toward women in general. He also noted that whether certain material appeared in the final film or was removed during editing was irrelevant, as the creative process often involves changes that do not constitute harassment. This included scenes that were ultimately cut, as well as moments during filming that were later reconsidered. The judge emphasized that the physical appearance of the lead character was part of the product being presented to the audience, and that achieving a certain aesthetic was understood as part of the role. She herself acknowledged this, requesting that certain scenes be scheduled later to allow time for physical preparation. She communicated privately that she was working intensely to meet those expectations, and believed that the visual appeal of the film was important to its success. She also compared the role to athletic preparation, indicating that physical conditioning was part of the commitment. Based on these statements, the judge found that Baldoni's actions, even if interpreted as encouraging weight loss, could not reasonably be considered gender-based discrimination. As a result, claims of weight-related harassment were not supported by the evidence. The judge then addressed the dance scene, which involved interactions during filming. In that scene, the script described the characters dancing closely, but did not specify exact movements or interactions. While she alleged that certain actions during filming were inappropriate, the recorded footage showed that the scene took place in front of a large group, with both actors improvising and receiving direction. The judge noted that such conduct might be problematic in a different setting, but within the context of filming a scene, it could reasonably be interpreted as part of acting rather than evidence of hostility or bias based on gender. Even if improvisation occurred, the actions were not so, far outside what might be expected in a scene involving close interaction between characters. The conduct was directed at the character being portrayed rather than the individual herself. The judge emphasized that creative professionals must have some room to experiment within the scope of the script without automatically facing liability for harassment. However, he did acknowledge that certain situations could come closer to raising concerns. For example, comments about personal experiences or physical appearance outside the context of the role could be viewed differently. He referenced testimony regarding comments about wardrobe and appearance, noting that such remarks could range from unnecessary to inappropriate. He also pointed out that referring to one's own wardrobe as sexy does not invite all forms of commentary on appearance. While these instances may not independently establish harassment, they can contribute to the broader analysis of retaliation claims. The judge also mentioned an incident involving a trailer, where entering while someone was in a state of undress could reasonably be viewed as problematic. Additionally, a scene involving a birth sequence raised concerns because, although blocking had been discussed, she did not anticipate the level of exposure required. The agreement specified that no simulated intimacy would occur without prior written consent. She stated that she felt pressure to compromise by performing partial simulated nudity under those circumstances, which became part of the remaining issues considered in the case. She was placed in stirrups during the birth scene, and it's surprising to some that this portion was allowed to move forward as part of the remaining claims. The scene itself lasted several hours, and she presented arguments that industry standards would typically require an intimacy coordinator for that level of exposure and physical positioning. Now, whether that argument ultimately holds weight is still up for debate. The judge did not explicitly endorse that position, but acknowledged that she raised enough of a question regarding those standards to allow limited consideration to continue. Importantly, she was not fully nude, which factored into the broader analysis. The judge also dismissed claims about a prior conversation involving personal topics, including one where Baldoni allegedly discussed intimate aspects of his relationship. He found that conversation occurred within the context of creative discussions about the film, and therefore did not rise to the level of unlawful conduct. The only area where the judge suggested a potential boundary issue was an alleged comment about her not having viewed adult content. That claim itself is disputed, and like several others, will likely come down to credibility, supporting evidence, and whether any witnesses can corroborate what was said. Another point raised involved a video related to childbirth that was allegedly shown. The judge stated that, for the purposes of the stage, it is enough to conclude that a person in her position could interpret certain workplace dynamics as reflecting a gendered or sexualized perspective, along with potential disregard for privacy. However, he made it very clear that these are still allegations and not proven facts. What he is determining at this stage is not whether the conduct actually occurred or whether it meets the legal threshold, but whether a reasonable person could believe it did under the circumstances. That distinction is critical. He acknowledged that a jury could potentially interpret some of these situations as contributing to a hostile work environment, but that does not mean they will. It simply means the issue involves disputed facts that are typically resolved by a jury rather than dismissed outright. The court explicitly stated that it does not need to determine whether the alleged conduct would ultimately support a verdict. It is sufficient that she may have reasonably believed it did. This shifts the focus to her subjective perception, particularly in relation to the retaliation claims. When it comes to the alleged digital campaign, the judge noted that there is a significant factual dispute between what Wayfarer claims occurred and what she alleges happened. Because of this conflict, the issue is appropriate for a jury to evaluate. He pointed to evidence suggesting there may have been efforts to influence public perception, including promoting content that cast her in a negative light. For example, there were references to boosting videos critical of her and circulating media narratives that portrayed her unfavorably. There was also mention of outreach to media outlets and strategic framing of stories questioning her actions and public image. A jury could interpret these efforts as part of a coordinated attempt to shift the narrative at the same time. The judge emphasized that engaging public relations or crisis management professionals is not inherently unlawful. Individuals and companies are allowed to defend themselves publicly, especially when facing serious allegations. Many of her complaints about a digital campaign were therefore deemed non-actionable. However, a few specific instances were identified as potentially crossing a line, particularly if they involved deliberate amplification of damaging content. Ultimately, the judge explained that the issue comes down to credibility. If the case proceeds, witnesses can be examined, and a jury will determine whether the actions taken were legitimate defensive strategies or improper retaliation. The key takeaway is that the continuation of these claims does not mean the judge believes her version of events. It simply reflects that there is enough disagreement over material facts to justify further examination. As a result, the case has been significantly narrowed. Most claims were dismissed, and no individual defendants were held personally liable. All claims against individuals like Baldoni, Heath, and others have been removed. What remains are a limited number of claims, primarily focused on retaliation. Specifically, there are only a few causes of action left, 2 tied to production entity and 1 related to contractual obligations. Everything else, including defamation, conspiracy, and the majority of harassment claims, has been dismissed. The judge also ruled that statements made by legal representatives were consistent with their defense, and therefore not independently actionable. Additionally, certain parties may still seek summary judgment on the remaining claims, which will further reduce or eliminate what is left of the case. When you step back and look at the broader picture, this ruling represents a major shift. The original case included numerous claims across multiple legal theories, but has now been reduced to a small fraction of its initial scope. Even the remaining claims face uncertainty. Moving forward will require substantial time, resources, and risk, especially given the limited potential outcomes compared to what was initially alleged. Another important point is that there are no remaining claims under federal employment law statutes like Title VII. All sexual harassment claims tied to those laws have been dismissed. What remains is strictly within the realm of retaliation under more limited legal frameworks. From a strategic standpoint, this creates a very different landscape. The burden now shifts heavily toward proving intent, causation, and credibility. Areas that are often difficult to establish conclusively. IT also raises a question of whether proceeding to trial is worthwhile given the narrowed scope of the case. Trials are costly and unpredictable, and with only a few claims remaining, the potential benefit may not justify the effort, and at the same time, the defense now holds a significantly stronger position, having successfully eliminated the majority of the allegations. This could influence any future negotiations or decisions about how the case proceeds. In the end, what matters most in a court of law is whether there's a valid legal basis for each claim. The court has already determined that many of those bases were not met here, and as far as the core issue of sexual harassment is concerned, the ruling makes it clear that the claims did not meet the required legal standard, largely due to the level of control she exercised over her work and environment. That concept of control is central to employment law. Without the necessary power and balance, many of these claims simply cannot stand. And in this case, that principle played a decisive role in shaping the outcome so far. Now all that remains is to see whether the reduced set of claims moves forward, or whether they too are eventually resolved before reaching a jury.